carries on my copy treatment.
আছে তলত দি দিব
Copy to treatment. Treatment.
নিশ্চয় তাৰপিছত
Yes, we have also two instructions. The
Mal-
second instruction is as regards the draft cheetah.
Mal-
This draft cheetah, which is there,
Lordship,
shows this land measuring 12 bighas, 2 kathas, 3 kathas, 9 lecha
Lordship,
of dag number 268, Purana 277 have become Sarkari.
Lordship,
And how the petitioner's name appears out there.
Lordship,
Now, if this land has become sorkari, how can you acquire ownership rights under the Tenancy Act?
No, Lordship, for the sake of argument, if it is deemed that the land becomes the Sarkari, but there is no such endorsement in the Chita or Jamabandi, how the land becomes Sarkari when it was a Patta land. Apart from that, even if the land becomes Sarkari, the riot will remain the right of the government. His status will not change as per the Act of 71.
Let's see. Does it say so? No, I don't think.
Lordship, here the pertinent question is this, that
No, the pertinent question is that only. Let us see if the land has become sorkari, rightly or wrongly, which has not been put to challenge.
Lordship, my
Can you get the acquisition of the ownership rights?
yes,
Show me that.
acquisition of right, that is Lordship section 23.
Understood. The
23. Originally, Lordship, the land was a government, as declared as a ceiling surplus. Then it was under the proceedings of the provisions of the Act 1956, Lordship. It become near the Lordship. It was settled with the original landlord, Kathari. So, and he paid the premium. The patta was issued in his name. Jamamandi was corrected, Lordship. After payment of the period.
Tenant means a person who cultivates or holds the land of another person and is or but for a special contract express would be liable to pay rent for the land to that other person, which includes the person who under the system generally known as so-and-so cultivates the land of another person on the condition of delivering a share or quantity of produce of such land to that person. Provided that a person who cultivates the land immediately under the state government is not a tenant within the meaning of this definition. If that be so, if the land is Sarkari, how can you become a tenant?
No, I am tenant since last more than 50 years, Lordship.
I'm not concerned with that. I'm concerned with the specific thing that if the land has become Sarkari, how can you have acquisition rights over the land?
Lordship, my acquisition, when I filed my application under section 23 before the DC for granting the patta Lordship, then it was forwarded to the government.
Merely forwarding does not make any sense.
And the
You are to
government-
no, kindly say. This particular document, Annexure A, categorically shows that it is Sarkari.
Sarkari, but how it becomes?
I'm not concerned with that. That you have not challenged. If you are a land under the Sarkar, in the under the state government, you are not a tenant, and thereby, how are you entitled to the tenancy acquisition of ownership rights?
My Lordship, may please to consider my righty Katyan was not cancelled.
Where is your righty Khatian?
If I-
Show me.
Lordship may come to page 18.
Page
18, one. Page 18, Lordship, annexed to Katyan number 528. Name of the petitioner is mentioned. Old new tag number. I am tenant only in respect of 1 biga 4 kata 9 less. Dot. Certified copy of the Katyan has been also annexed in vernacular.
You are writing Khatyan against in whose land?
Land of lordship. Name page 16, lordship. Name of the land is mentioned. Page 16, column 3. Name and address of the patadar, Tukura Kasari, Hati Kasari, mind or Mata Siddhi. So it is, apart from that, interesting part is this lordship. Please to come to page.
No, understood. But here you see, dark number which is there is Purana is 260, 284 and new is also 284.
It happens sometimes during settlement operation.
Huh?
Same serial number comes lordship during resettlement of it.
And when was this issued? Annexure 1, page 17.
Next year one, this was
This
issued.
is of 5764.
Next page, yes, Lord.
And this Khotian was issued when? This is 7586. How can this Khotian be issued to you when the land is Sarkari?
Land is Sarkari, but how it becomes again, I am
No.
same
First
thing.
of all, there has to be the basis. The basis has to be that you cannot claim ownership rights under 23 in view of under the being a tenant. You cannot be a tenant.
Lordship, may please to come to page page Lordship 22.
Huh?
Page 20,
Yes, 20.
22. This is the Jamabandi Lordship.
That is what on top if you see. This is the Khotian. Page 20 is the Khotian.
Page 22 is the
Page 22.
It is page 22.
Yes, page 22.
Here at the bottom, Lordship will see application number so and so of the year 1960 ASO dated 30th 462 and 547 number challan dated 24/5/62. Premium paid having serial number itna, tag number itna, land allocated in new patta of the year 1369. This is Assamese calendar. And next page is the vernacular of the Jamabandi. So it was earlier, it was a ceiling surplus land under the Act of 1950, and it was subsequently allotted in favor of the Tukura Kasari, Bhati Kasari, Minor Mata Siddhi. So thereafter, how the land will become Sarkari law?
My lord, we have
The earlier endorsement
we
by
have filed, my lord, affidavit in opposition by respondent number 4, my lord, on 6/2/2014. Lordship, may be pleased to peruse the paragraph 4 of that
Very good.
affidavit, my lord. Filed by Bharat Bhushan Deshpur.
Rajati Khatian 524 of PP Patta number 7. So there is no mention of Moza and village. It is only a draft data of 57 that there is a mention of the state land as accordingly. Land measuring covered by Swan is a government land and Gobat. Further, as per record, there is no mention information of any riot or Khatian on the state property. However, as per the Chita 1912, because of the land of the number email patta, but there is no mention of any patta number. On the other hand, these so are recorded as patta, but as per the remark following, the name of the pattatas were cancelled as Khatian number. However, there is no order. We mentioned that the name of the Jagati Sukha father, according to
not a single document has been annexed to the affidavit.
they have produced this thing, the Chita 524, which has been shown as Sarkari.
But Lordship is well versed. Whenever a land is made Sarkari, it is always mentioned in the remarks below that how it becomes the Sarkari. There is nothing. It shows the bungling created by the revenue authorities at the behest of the private respondent,
Who is the private respondent?
Nirmal Kumar Sharma.
Kali Prasad, Kalidas Sharma.
Kalidas Sharma. Kalidas Sharma Lordship is not a resident of Perkuti, he is a resident of Guwahati University campus Lordship. He was the one of the petitioners.
And how does the private respondent come into the scene?
He stated that he is the secretary or president of Balaji Unnayan Samiti of Perkuti.
Then
He claimed that there was a Kopat and road has been blocked by the police. And by that lordship, they have constructed illegally and possibly a road because just on the backside of my land of one Nirmal Kumar Sharma, who is a Marwari business, situated. He had no way, approach road up to his plot. So he managed Mr. Kali, the Sharma Lord, and he was implemented, and then the lordship.
yes, you are paying for whom?
I'm appealing the private respondents, Nirmal Kumar Sharma and Kalidas. Sir.
Nirmal Kumar Sharma is where? I don't see any Nirmal Kumar Sharma.
Now we have filed this IA for implement,
Okay.
IA number 111.
Ah.
And another is, IA number 52 for, stay vacating the, the order of status quo.
Huh?
Lordship, I have given a map showing the land of Nirmal Kumar Sharma. His claim is 20 feet wide road.
And JP Gupta's land means you have land.
Yes, I'm in occupation. I was in occupation. Sir.
No. This land you are mentioning out here is the land where you are in, you were in occupation.
Yes.
And now you are not.
No, I was evicted for 3
Now,
months.
in this land, you are asking that tenancy, this occupancy right be given. And this making drain is what?
Making there is no such drain lordship. They have shown this map was submitted by Mr. Dr. Khalid Sharma Lord.
Okay.
Showing the drain and the road, but practically there is nothing. My land was entire land, 1 bigger was surrounding with 4 sides RCC wall plot. Through the days of my father, I was in position. More than 50 years. Nirmal Sharma has also filed an application for his impeachment, which has not been disposed.
This 524, as it appears from the map, is just a road.
No, Lordship. In the cadastral map, Lordship, there is no, and in existence, there is no such.
No, there is a
After
road.
evicting,
You see, 524 is around, the breadth will be around 65 feet, 62 feet, 60 feet, 60 feet. And while the land comes down, it becomes 60 feet. Whereas on its left and right, you are having other land, 534, 519, 520 and all.
so that may be NH lot.
Hmm.
NH lot.
Huh?
NH.
No, NHA is not there. NHA is on just other port.
But physically, Lordship, there is no road for
Oh,
going up.
524 is the road as could appear from these documents. And when were you evicted?
I was evicted, Lordship. एक बोलो ना. No para. I was evicted, Lordship, on 2830.
2813.
2830. That that is clearly mentioned in the other petition, Lordship. But it's not there. Here, para 27 in the present topic. Page 8, para 20. Without issuing any notice, Lordship, Nirmal Sharma, that he had come along with the circle officer, police official, and demolished my boundary walls, houses, and took forcible foot.
So we are only concerned with 524.
I am concerned only. whole game was planned by Nirmal Pramad because he had no approach plot up to his plot, which is a big chunk of plot, approximately more than 10 acres.
524,
My
528 or 524?
my dog is lot better. 284 old lordship, old is 277, new is 284. As
Wait,
per the
yours
article.
is 528. 528. 528 land is where?
Five to four is the new dag lot. 524 is a new.
Now, are you into 524 or 528?
No. Earlier my dag was 284, then it become 277. Then in the last settlement operation, it become 524.
No, you were given the Khatyan in 524.
My Khatyan is lordship. Earlier it was page 16 lordship,
Page 20,
page 20 lordship.
528.
Page 20 is lordship 284 and 284.
Dark number.
Yes.
The Khatyan number is 528. Na?
Yes.
So in 284. Now this 284 became 524.
Yes, Lord.
Now your application which you have filed, two 284. How do you say that the 524 became 284 became 524?
In the last till I have made a government lordship in the petition.
No, governments won't help. 284 became 524.
Lordship, it is clearly mentioned at page 22, giving all old and new documents.
52, page 23.
22, Lord. This is Jamabandi. Top Jamabandi.
No, where are we getting 524 from here?
Five to four lordship that was given in the last settlement operation. It is a Jamabandi of year 1957 to 64 settlement operation law. So at that time, old docs are given in the second column and new docs are mentioned in the.
No, show me the place where we can find 524.
5 to 4. हथियार निकलता है।
284, it is only found from the affidavit they have filed that 284/299 became 524.
Yes.
But there is no document out here to show that it became 524 from your document.
Ether Lordship, my learned friend has submitted.
Hmm.
Submitted the argument that crime branch has said. There also it has been so. But as the documents are not available in the TC office Lordship, we also cannot obtain certified copy. And I have filed an RTI for obtaining the copy that your Lordship will find it page 29 and page 30. Page 30 of my last page of the writ petition. They could not supply.
Now, this document is there, the Chita.
My learned friend has told me that it has been seized by the crime branch.
No, this was given at that point of time. Long time.
Lordship, here the pertinent question is whether a person, Lordship, even if he is a stranger, encroacher, he can be evicted without giving any notice, Lordship.
That can be done. If you are in a possession of government land which is used for roadside or area, now to in view of 18(2), it can be done.
Lordship, that can be done under Rule 18. But here it is not the case of Rule 18, Lordship. I am having the Khatian in my name, Lordship, from the days of last 50 years, Lordship. I have had houses, electricity connection, 4-side boundary wall. In that case, I am not entitled to get a notice. A person, even under Rule 18 to Lordship, there are judgments of this honorable.
No, Mr. Roy, that question is already over about the notice not being there. The question therefore is here only remains now you have already been evicted. That cannot be again brought back. The only question out here is as to whether you can be given occupancy tenancy rights in view of the fact that the land has become government. That is the question. Earlier, all other questions becomes meaningless now.
Then in that,
All other
Lord,
questions you should have
I may be
hesitated
given-
in
I may
2013.
be given some time to.
For what?
For-
The time is not there. That is why I gave you time on the last occasion.
Then in that even Lordship, maybe please to allow me to withdraw. I'll file a
You'll file?
civil suit. I may be allowed to withdraw.
I think that is better off.
Because there are many disputed questions. of fact. Yeah.
And what is this Kali Das Sharma's petition?
Well, this was against them in police matters, police high-handedness. That was against the police high-handedness matter at that point of time.
You are the person who filed it.
Yes. I'm the
Hmm.
person.
So now you don't have any problem.
Now the road has been completed. The
No,
big
Mr.
road-
Counsel, tell me, do you have any problem now?
No. Now we don't have any.
Your
problem.
name?
A.K. Das.
So and so the learned counsel appearing on behalf of the petitioner submits that the petitioner for the present is not any more aggrieved with the impugned actions for which he would not like to press the petition, and accordingly the petition stands closed on withdrawal. There are two cases, na, Mr. This is we passed this order permitting you to withdraw and file a civil court in WPC number 4765 of 2013. In the other one, that has become infructuous now in view of this. The Mr. S.P. Roy, the learned counsel appearing on behalf of the petitioner, submits that taking into account that there are various disputed questions of facts, he would not like to press the instant writ petition. but rather approach the appropriate forum in that regard. Taking into account the above submission, the instant writ petition stands closed on withdrawal. It is made clear that the withdrawal of the instant writ petition shall not preclude the petitioner to avail other remedies available under law. And shall not preclude and prejudice the petitioner to avail other remedies available under the law. Accordingly, the instant writ petition stands closed on withdrawal. Interim orders, if any, stands vacated. WPC number 848/2015. The learned counsel appearing on behalf of the petitioner, Mr. S.P. Roy, submits that he would not like to press the instant writ petition. Accordingly, the writ petition stands closed on withdrawal. Interim orders, if any, stands vacated.
Okay. Apply.
Apply.
And now for yes, PMLA.
Yes, Peter. My lord. First, I like to draw lordship attention to the section 2. Definition, my lord, regarding the
Section 2. Definition of
my lord, proceeds of crime.
Hmm?
Proceeds of crime.
Okay.
You. Your lordship.
Hmm.
The proceeds of crime means the property derived or obtained or directly or indirectly by any person as a result of criminal conspiracy relating to a schedule of that's very first part has to be related to a schedule of or value of such property or where such property is taken held outside the country when the property equivalent to the value held within the country or abroad. Explanation for the removal of the doubt is hereby clarified that the proceeds of crime include the property not only derived or obtained from the schedule offence, but also any property which may direct or indirectly derive or obtain as a result of any criminal activity relatable to the schedule. In both the cases, schedule offence is the mandatory required. Now, Lordship, can see my first contention for your Lordship. Can turn to the provisional attachment order, page 33 of my writ petition. In this provisional attachment order, there's not a single whisper, first of all. There's the property which is provisionally attached, that is the 3 property. The first one belongs to me, the rest of 2 not belong to me. The page 48 is the schedule of the property. There are 3
Are you saying that property number 2, at serial number 2, does not belong to you?
Yes, it is Farida Sultana and Farida
Huh?
2 and 3.
Page 40.
It's a wife.
Huh?
It's in the name of my wife.
Where? No,
Is-
page 20,
Yes, is
40. The
What?
petitioner is Muhammad Aftabuddin Ahmed.
Yes.
Land measuring so and so, so and so, so and so.
Yes. There are two petitioners.
How many petitions?
Two petitioners. Husband and wife.
The provisional attachment order is against whom?
Husband and wife.
Both.
Both. The first time coming to the schedule 1, number 1.
Hmm.
Petitioner number 1.
Yes.
This point is for the petitioner number 1 regarding the schedule of. Now, these my first of all, Lordship will find in this particular order, provisional attachment order, there's nowhere there's a whisper that this property is acquired by the petitioner or it is a proceeds of crime. Nowhere. There's no avertment to that effect.
What is 8.1? Page 44.
Yes. It appears that the Aftabuddin Afternoon acquired proceeds of crime out of the commission of the scheduled offences PMLA and subsequently laundered the same in investing them in acquiring the different properties and also investing them in the name of himself and himself member. Hence, the property acquired Aftabuddin in his name or his name of his appellate word from his friend store is sorted out by the vigilant anti-corruption. Same are not nothing other than the proceeds of crime derived from by the commission of the scheduled offences under the PML. Now, perfect kindly see what are the requirements. There states it is under the PCA. Schedule offense.
Hmm.
My concern is the schedule offense.
Hmm. So it became sometime in 2005.
Yes, this has come as a schedule offense in 2009, 1/6/2009.
Ah.
The PC Act. This property was acquired in 1997.
No, here they have attached.
The sale deed, my lord.
No. Here they have only attached these at page 48.
48.
The other properties have not been
They
attached.
have not touched. Only
So-
3 properties.
Only these 3 properties. So these 2 properties come within it. 2 and 3
2 and 3,
comes
Come.
within it,
Yes.
but 1 does not.
1 does. So it's not, doesn't belong within the schedule of. So it's a jurisdictional error. First of all, the fundamental error. The moment it's a fundamental error, it becomes a jurisdictional error. So this court has the jurisdiction to entertain. First of all. Secondly, my lord, so these property goes beyond the attachment because they can't attach this particular property
Of 1997.
of 90.
The other 2 they can.
Other 2 I'll come later. The rest of the. So first of all, my argument is the first property regarding the petitioner number 1. It is at the time when it was attached, because the PC Act is not in schedule. It has come in 2009. So it was not schedule offense. So it can be derived as a proceeds of crime. Both are connected. There is no retrospective effect also. So that is the proposition of. So this is the first property of. Now this is second, 2 and 3. Now the question has come, madam. This is lordship can see. This order has been issued under the second provision of section 5(1). The 5(1) what it says, madam, the provided take the 5 second proviso, because the 5 proviso does not play here, madam. 5(1) does not 5 proviso, second proviso. Because for the first one, they have to lay the complaint first before the trial court under 173. But the second proviso, it's not necessary. They provided further that it not necessarily anything contained in the any property of any person may be attached under this section if the director or any other officer not below the rank of the deputy director authorized by him for the purpose of this section has reason to believe the reason of such belief to be recorded in writing on the basis of the material in his possession, that if such property involved in money laundering is not attached immediately under this chapter, the non-attachment of property is likely to frustrate any proceeding under the chapter. So now reason to believe, first of all, and now the second and third requirement, my lord. Now, lordship can see the provisional attachment order, as I already pointed out, paragraph 17. There's nothing to that show that there is any reason he has recorded in the provisional attachment order.
No, it is not required to be recorded here.
Yes, I'll come to that. Okay. There's probably one judgment. Said it's likely that sometimes it's required. The one judgment. Sometimes when it is required, but not under the PMLA Act. The similar provision of an NDP. Just decided by similar provision regarding the attachment of the property under the offense commission of the offense. Now, it has been not given to me, madam. So, what is the requirement of the law? It has to be in writing somewhere, or they have to intimate it to the authority concerned. Now, here admittedly, they have not done it. I don't know what is there. Secondly, my lord, the complaint they have given to us to the appellate authority, it does not also contain the similar reason. And under that,
But Mr. Bora, we are only on the provisional.
yes, provisional. That's my, just to show it to someone for other reasons. I'll come to that. So the complaint which they have filed before the authority concerned, immediately within the month, that is the 30 days, they're supposed to file it before the appellate authority. Under 5 of the PMLA Act. So in that complaint also, because these are my material which I have possessed before this book, and by way of additional affidavit, I have brought it out. That was subsequent development. In that, on the receipt of that complaint by the appellate authority, they have also issued a notice adjudicating. In that notice also, there's no reason has been given. So why I am saying so, my lord. So going back to the appellate authority is this case. So they have allowed the continuation of the violation. The violation that has continued from the attachment, provisional attachment, which has been continued, they have allowed that continuation, that provision, violation, by issuing the show cause, by issuing that on the basis of the complaint. Because on the basis of the complaint, they can't, because the complaint, there is no reason at all. But they have allowed to continue that violation. So now the question of going back to the appellate authority, as my humble submission before your lordship, may not be right at this.
Mr. Bora, let us see the judgment of the Supreme Court, because otherwise I'm not satisfied with this submission. So let's see the Supreme Court judgment on NDPS matter where
Yes,
it
I'll come. But my thing is that the moment the lordship, I don't know why lordship is not satisfied, but the one thing
no,
is
because
lordship
the
is
law is very clear. Mr. Bora, the law is very clear. Reasons to
Recorded.
believe and reasons to be recorded are not required to be put
okay,
in the
but
notice.
that's true.
But they have the reasons, as I could see on the earlier occasion when the matter was taken up. As I
If
was
that
always
reason-
telling
no, no.
you,
If the lordship is satisfied, if they have a reasons has been recorded in the file.
there's reasons have been recorded. That has been shown to me on the earlier occasion.
Okay, because that's I'm not with that. I don't have that material. So what reason under which belief? Because there has to be nexus with the property concern, madam. Only their belief will not do, madam. It's a subjective satisfaction of the authority concern that because of these are the factors, we have the reason. Which factors? I don't have that factors, madam. They might have in the file, but in the complaint also they don't have the factors. That's what
No,
I'm
what
saying.
is the nexus which has to be taken into account? Can you
The
see
nexus is
the nexus is
reasonable nexus with the property
that
concern.
if such property involved has reasons to believe to be recorded in writing on the basis of the materials in its possession, that if such property is involved in money laundering is not attached
Yes,
immediately under the chapter, the non-attachment is likely to frustrate any proceedings.
yes.
So the reasons to believe has to be in connection to that.
In connection to that, and there has to be some material also that I'm going to sell it, I'm going to dispose it. Some material, concrete material has to be there. Simply just the copying the section, that will not do, that is humble subject. They may have,
Or we can put it in this manner, in a much better manner, to the effect that there is no live link between the reasons recorded. Because as you know, the reasons have been recorded. With the
Yes.
reasons recorded, with
the
the
property concern.
requirement that the property which is involved in the money laundering is not attached. Immediately the non-attachment with
So
so
these
your
property-
submission, if I may just put it in this manner, that there is no live link or any reasons to believe, more particularly taking into account that it was not a schedule offense pertaining to the purchase of property of 1997. So their attachment or the reasons which have been recorded
Yes.
is a non-existent reason
Yes.
for the purpose of provisional
Lordship is
attachment in
absolutely
respect to the
Yes,
97.
Lordship, that's my point. Lordship is absolutely correct. So that reason I don't have whether that reason is there or not.
Now
If
that this court will look into it.
Yes, yes. If
I'll
that
look into
reason
it
is
and
there,
then that has to have
that Lordship is absolutely correct. But if that reason is there, live link as Lord says, the nexus, the proximity,
there has to be a proximate
proximate
link.
connection. Yes. So if there is a proximity is there in their reason, then I don't have case at this stage. Maybe in the later stage I have a case challenging the appellate authorities order.
The sufficiency of the reason.
Yes, sufficient. So at this stage, if they can show it to the Lordship, say yes, there's a live link and the proximate connection with the property. If it is this property is not attached,
And more so
it is
when
frustrated.
and more so when it is the requirement of law that the
Yes.
reasons to be recorded has to be in respect to a property involved
Yes.
in the money laundering,
Yes.
which could not be solved in view of the fact that in 1997 property purchase,
Yes.
it was not a schedule.
Schedule of payment. That is one part. And the apart from also, my lord, as you talked, that is now the property which I am holding from 1997, whether there is any live link,
That is what
that is the second part. That where I am trying to sell it. If I am selling it, it will frustrate the whole procedures of the whole trial, my lord. They have to show it, how it will frustrate the whole procedure. They have to show it in the record. So these are the two factors, madam. So why what I am taking in account, madam, why I am showing it to that complaint? Because as per me, madam, the complaint also should say something about. Though it was not, we have not challenged the appellate order, but the complaint they have forwarded immediately within the 30 days. That is why I am saying, madam, why this is important. Though it was not challenged, but that they can deny. The complaint they have forwarded within 30 days of the first provisional attachment. In that complaint, why they are silent about this fact regarding the reason, the link that the document said, that they then think is absolutely missing in the complaint. And that is my another, by way of affidavit I have brought in. That's why I'm saying that they have no live link or the nexus with the property. Neither 1, 2, and 3. So, regarding 2 and 3, the second part of my link, as I said, there's no live link regarding 2 and 3. And apart regarding 1, my lord, apart from live link, they can't even attach because it does not fall within the ambit of the PMLA Act, schedule of. But the rest 2 is in falls within the schedule of, but this is fine. So this is my one part. And the now to that effect, my lord, regarding that there's one judgment of the Delhi and Punjab division bench, my lord, regarding the schedule of it, that I am relying, my lord.
Yes.
But this is why important, my lord. Otherwise, it's not very binding on your lordship. It's a division bench judgment of the party and Punjab. But these was challenged before it by the authority and trustee. Paragraph 35. In our considered opinion, to understand the true meaning of second limb of the definition of the proceeds of crime, it must be read in conjunction with section 3 and 8 of the PMLA. If all these sections are read together, face value of such property does not mean they include any property which has no link or direct or indirect with the property derived or obtained from the commission of the scheduled offence. That is the alleged criminal activity. The value of such property means the property which has been converted to another property. Is not, then logic can keep it to these. Then The question was from paragraph, para 39, my lord, whether officer attacking property is required to record the region property. Then sorry, I'm sorry. One more bit. On the last occasion, I have given that statement, madam. It is the Telangana High Court.
Yes.
Your Lordship,
Now, in this judgment, kindly come to that Punjab and Haryana High
yes,
Court.
yes. Paragraph 50, my lord.
No, kindly come to paragraph 44, where they refer to the judgment of the Supreme Court in 2008 for SCC 144.
Paragraph, my lord.
Paragraph 44 of the Punjab and Haryana High Court.
Yes.
And kindly come to the paragraph 44 and then paragraph 33 of that quotation.
Yes. The court is entitled to examine whether there has been any material available to the state government and the reasons recorded, if any, in the format of formation of the opinion, and whether they have any rational connection with or relevant bearing
on the
on the formation of.
So that is what is your
Yes.
submission.
Yes. So now, Lordship, kindly see, this is one part, and second part regarding the
And down below the
51.
next, the court is entitled particularly in the event where the formation of the opinion is challenged to determine whether the formation of the opinion is arbitrary, capricious, or
and whimsical.
whimsical. It is always open to the court to examine the question whether the reasons for formation of the have a rational connection or relevant
Relevant
bearing
bearing.
to the formation of the and are not extraneous to the purpose of the statute.
Yes.
So that is what you
Yes.
are. Your
from the note from the first attachment order
Hmm.
and the complaint.
Yes, you are now referring to Telangana.
No,
judgment?
Lordship, country 51 also.
Page?
The conclusion in the 51. Yeah, Delhi High Court.
No, not Delhi. This is Punjab and Haryana.
Punjab, sorry, madam. The 51, madam. In view of the discussion and the summarize the findings as below. In case of pieces are important. Number 2, the property acquired prior to the commission of the schedule offense is important. The criminal activity or introduction of the PMLA cannot be attached unless property obtained or acquired from schedule offenses is held or taken outside the country. The director and any other officer authorized by him is bound to record the reasons, which must be specific, and mere reproduction of the wording of section 5 is not. So, the Roman 2, the first one goes out of it because of the jurisdiction. The moment it's a case of a jurisdiction matter, the Lordship has the authority under 2. So
In fact,
Lordship can
as
exercise.
regards this very aspect, I think the matter, the Supreme Court has also decided if it does not fall within the schedule offense, then also you cannot attack. But the question arises, if that be so, why can't you appear before the authority and show this very judgment out there?
That's true, my lord. See, that's true. But now the question is.
You
when-
can very well show these
Yes,
very
that's true.
best
Now,
can be
that's why
shown.
I'm saying, my lord, now at this stage, going back to the appellate authority.
No, not the appellate authority, the adjudicating authority.
Sorry, my lord, the adjudicating authority, when they have already applied to mine on the basis of their complaint, they have issued a notice. In the notice, they have said, I have committed the offense under the schedule. It as per their note. They have already decided that.
That is another aspect.
They have already
That
decided,
is
my lord,
only,
this
we are
aspect.
only, I am only here to look into the provisional attachment.
That's true, my lord. So, as I am saying, Lordship can definitely can, but where the Lordship can see there is a fundamental effect
Hmm.
on the face of the record itself.
Anyways, let's come now to this Telangana judgment.
Telangana High Court, my lord.
Yeah.
So, Seema Gorg, they have challenged, my lord. The Supreme Court has rejected, my lord.
SLP dismissed,
Special district.
so it becomes just a judgment of the Punjab and Haryana.
Yes. Well,
The Telangana High Court, I have it.
now, in the Telangana High Court, Lordship kindly first I'll actually want to paragraph 84. my lord.
Where?
Paragraph 80, para 73. Part of the.
Hmm.
Now, what happened in this case, my lord?
This was on appeal to the division
Yes,
bench.
appeal. But in the appeal, they have also struck down the original order of the original decision of the attachment provisional.
So now you want to do it by a single judge, yeah.
No,
In
no,
a 226, rather than doing it in the 42 in a before
No,
a division bench.
this is this is a division bench of the
No, understood, because I think the 42 applies to the division bench.
So,
42 appeal is before the division bench.
no, this is not an appeal under.
No, this is an appeal under 42.
Yes,
So the appeal under 42
this is
lies
an appeal
before the
under
division. So instead of that, now you want the
well,
single judge.
I'm on the finding. I'm on the finding, my lord. I'm on the finding. What is the finding of the?
Okay.
I'm on the finding of just one line. The paragraph 73. Appellate tribunal examine the order of the adjudicating authority. This not. The Lordship can next page, my lord. 85. The state observations are contrary to the law laid down by the Honorable Supreme Court in India, wherein it is held that recording of reason is mandatory direction under the law, and non-communication thereof is not save the showing that the reasons exist in the file, although not published.
This is which judgment?
This is the Telangana.
No, no, no.
Division
This,
bench.
no, no. This 84. Where is it? 84 says 84 and
Paragraph
85.
73, ma'am.
No, 84 and 85 is
Yes.
of the appellate tribunal's order.
No, the state observation. This is the observation.
No, kindly see the
Yes,
tribunal.
this is tribunal has finding.
This is the tribunal's file.
Yes.
Because these aspects of the so I don't know where the Supreme Court has said
Yes,
this.
that I couldn't also find it
No,
out.
obviously it can't. Because if you see
But
this
they have said that
judgment,
the emphasis is there, my lord.
no,
I tried it.
kindly see this judgment,
Yes,
page 61.
Yes.
Paragraph 61, you see it. Where he is, the Telangana High Court is referring to the income tax laws, more particularly what is the reasons to believe.
Yes.
And then it has been mentioned in paragraph 62 as Narayanappa versus Commissioner.
Yes.
Again had the occasion to examine the expression in the context of Iman. It was pointed out that the expression reason does not mean a purely set upon the Iman, so and Iman, and so not the reasons to believe. But this particular judgment, as Narayanappa, you have it? Yeah, give it to him. That categorically mentioned there were 2-3 points which were involved as to whether the reasons are to be handed over.
Yes.
That was the submission. He said no.
No.
these reasons are not required to be given.
Yes. But
Because the act, the only
Because
says recording of the reasons.
recording of. But I don't know where from that the Supreme Court this part has come in. Even I tried my best, but but anyway,
Now, Mr. Bora,
my lord.
I think these are your fundamental. Let me get to them as regards this. What are the reasons to believe they have recorded? And how did they bring in the 97 thing? Then you reply on that.
Well.
Yes. Madam, how did you bring the 97 property?
Yes. Hello, shall we see the paragraph page number of the writ petition, page number? Page number 50.
48?
No, mother. 33, 34, 35, 36, 37, 37. Start from 37, my lord. Last 5.1, my lord.
5 point?
5.1, my lord.
Okay.
Aftabudi Ahmed has inter alia stated that statement that 31.7 stated so and so that he was working as a deputy conservator of the forest under the forest department government of Assam, but at the present he is under the suspension since 2018. Though basically he belongs from the family of farmer, but his father was a school teacher. He got married with Farida Sultana in the year 1985. They have two children, son namely Arik Aftab and the daughter Tamsin Aftab. He has inter alia stated that he is having the following properties in his name in the name of his family member. That is the list of the property, my lord. From 5.2 to 5.12, my lord. Then 5.13, my lord, that during recording the statement, Farida Sultana, under the section 50 of the PMLA 2002-60, she had inter alia stated she is an earning lady of having her own income. She had few commercial vehicles. That is the statement of the my lord Farida Sultana. Then my lord 5.14.
There is the sun.
Yes, my lord.
I've read it. I've
Yes.
already read it. That is
Then-
why I could find out 8.1.
Yes, my lord.
Yes. Now tell me, how did you bring the 97 one? And why there is no reference of this 97 in 5.1 and 5.12, 5.1 to 5.12? This property, there is no reference. Why?
My lord,
Why there is no reference in this from 5.1 to 5.12 to this property? Where did you get all this property from?
that is my lord in page number 55, my lord. That property is recorded in page number 40, my lord.
40, I've seen it.
My lord, page number 40.
If you see page 39, number 6, and whereas the following properties held by so and so have been identified.
Yes, my lord.
Okay.
Yes, my lord.
Now thereupon you bring in this property. Where do you get this property from?
My lord, this is the
In your
property.
notice. I'm coming in 5 minutes.
Yes.
And
What is this? Yeah, that is 58, 55, 95, yes. Another is,
they have so many properties.
yes, my
You
lord.
have only chosen
11, 12,
three.
and 1, my lord.
You have not done provisional attachment in respect of all other properties.
Yes, my lord.
You have only done for 3.
Yes, my lord.
Why have you chosen 1997 property?
My lord, kindly see, my lord, section 2U, my lord.
Huh?
Section 2U, proceed of crime.
Hmm.
Proceed of crime means any property derived, obtained directly, indirectly by any person as a result of criminal activity, my lord. That is
Relating to a schedule offense.
relating to schedule offense.
Schedule offense.
Schedule offense or the value of any such property, my lord.
Hmm.
Value of any such property or where the property is value or where value of any such property. My lord.
Hmm.
That is written in proceed in section 2U, my lord.
Understood.
Yes, ma'am.
But it has to have some relation, proximate relation with the scheduled offense.
Yes.
But
But-
that property could not have been purchased at the time when it was purchased, was not a scheduled offense at that point of time.
My lord, for that, my lord, my humble submission is that, my lord, under this act, my lord, Prevention Money Laundering Act, my lord, there's a provision to defend before the adjudicating authority.
That
my
I
lord.
know.
And my lord, in earlier, there are two cases before this High Court, my lord. Then they have filed under 226, my lord. That court has, my lord, dismissed both the cases, my lord. That 226, that court, my lord, record it is here, it is, my lord, stated in that is in WPC 81 2019 passed by, my lord, the High Court of our High Court, my lord. Accordingly, in view of foregoing reason, the court is of the considered opinion that present is not a fit case wherein this court should interfere with the order of provisional attachment. Here also they had, my lord, challenge the provisional attachment order, my lord. In exercise its power under Article 226 of the Constitution of India, in as much as this court has held that the authority it is having its power and jurisdiction to issue the impugned order of the attachment, that adjudicating authority is having the power and duty examine the validity of the order and attachment and and test the same is including the ground.
Madam, all these are understood.
Yes, ma'am.
But the fact is, isn't there a jurisdictional error in respect to the 97 property? Not the others.
Yes.
97 property.
That is, my lord, I have filed our affidavit also. That is a continuing offense, my lord.
How can it be a continuing offense when a property was purchased in 97? Is there any allegation that he has been involved since 1997 in your reasons to be recorded? Let us see the reasons recorded. When did you become a DFO?
I have joined in 86 months.
No, DFO. Yes, Mr.
Please, sir.
Officer, you are,
Sir. I'm assistant director,
your name?
Naveen Gupta.
Okay. You have seen the reasons to believe.
Sir.
You put that 97 property in order to make it 1 crore 42.
Sir, because the value thereof, sir, if property dissipated, then we go to
No, because you found out that out of the assets and disproportionate assets,
Yes.
the missing amount amounts to 142, which does not tally with
Tally
their
with my-
income.
My
Sir.
income, yes.
142. So therefore, it was easy. Number one was 60, 56. It seems that you have done it in that manner. Number one is 58.
Yes.
Number two is
30 crore here.
number two. You got hold of 60. Where is that 60?
60. And third one is
60 and the number is 30.
30.
So it becomes easier to get 142. So you have done it like that.
sir, the DA amount, sir, disproportionate estate amount, he utilized that amount. So if utilized by that amount, then we go to serious procedure. We can go to serious.
No, this is for the purpose of confiscate. If you confiscate, you can realize that amount.
Sir.
That is the reason why you have done it.
It's a kind of a reverse engineering.
Mm.
But the fact remains, my lord, it can be a offensive property. Offensive proceeds of crime. 97.
And other two, if we add the other 2 to 10, to 2 to
2 to 10, but
no 2
2 to 12.
no. It has come in 2009, no, Mr. Bora?
Yes.
Yeah.
Yes.
So otherwise, if you add 2,
2,
5,
5, 6,
6,
9.
9, it does not add to that 58.
Yes.
That is the reason why you have done it.
So in proceeds of crime definition itself, it is given that value of such property can be considered as proceeds of crime.
But it has to be a scheduled offense, first of all. At that time, it was not a scheduled offense. Both have to be satisfied, my lord.
Now, have you done anything as regards the bank accounts? No.
Yes, the bank account balance, not that much.
Why? If we see page 42,
Amount credited. Not that it is, well, the last is amount credited, not the total.
Hmm?
That is last
Total.
total amount is last column, my lord. Amount credited. See that? Okay, good.
And you have taken the value as on the date of purchase.
We have to rely on the sale deed.
Sale deed value.
The purchase of a land which is of 1997. You must be aware that the property must have gone 300% higher.
That to one katha, one late.
No, one more than that.
First on one katha, 10 late. That in Beltola.
One katha 10 lakhs in Beltola.
In 1990.
Your property number 2. It's a flat K127 Chittaranjan Park, New Delhi. Entire first floor is of 60 lakhs only. They'll cover everything. In fact, your property and number 3 will also cover everything. Anyway, now let us, therefore, we have to confine ourselves as to whether you can do so in respect of those properties which were not a part of the schedule. You have allegations, you have made allegations out there from 1986, from the post of the year he has been doing it. But the PMLA Act was brought within, this became a schedule offense in PMLA only in 2009, May 2009 or something. So therefore, let us see, proceeds of crime means any property derived or obtained directly or indirectly by any person as a result of criminal activity relating to a schedule offense, or the value of any such property, or where such property is taken or held outside the country, then the property equivalent in value held within the country.
That is different.
Because they are on the value of any property, or the value of any such property. Yes, what does this Punjab and Haryana High Court hold as regards this thing?
That is the paragraph 51.
Acquired prior to the commission of the schedule offense, that is criminal activity or introduction, and cannot be attached unless the property obtained or acquired from the schedule offense is held or taken outside.
There is one more judgment of Karnataka High Court.
How many?
Same point. Paragraph 12, my lord. Here the provisional.
Now kindly come to paragraph 32, 31 of that judgment,
Which one?
of that Punjab and Haryana.
31.
Hmm.
The property purchased prior to the commission of the schedule offense, leaving aside date and enactment of, does not fall within the ambit of the first limb of the definition of proceeds of crime. However, it is certainly falls within the purview and ambit of the third limb of the definition. Counsel of the both sides has cited the judgment of the Delhi High Court in the case of the to support their content. As per the judgment, if the property derived or obtained from the schedule offense is taken or held outside India, the property equivalent to the value held in India or abroad may be attached and irrespective of the date of purchase. So I must have a property fine, first of all, in outside. Then only the value can be attached. Then my 97 property, that is my understanding.
So it says, as per the said judgment, if the property derived or obtained from the schedule offense
Yes.
is taken, means that property can be taken, made by an immovable property also, if it is taken, some diamonds, let like that. Or held outside, if you have an immovable property
Yes.
outside, then the equivalent of the property in India can be
Yes.
attached.
Yes.
That is how
Yes.
it has to be there.
Yes. Something must be in outside.
Or may be attached, irrespective of the date of purchase.
Yes.
We fully subscribe to the opinion expressed by the we find that the third limb of definition here covers property equivalent to the property held or taken outside.
Yes.
Thus, the date of purchase of the property which is equivalent to the property held outside India is irrelevant. Any property irrespective of the date of may be attached if property derived or obtained from Chile is taken or held outside India. The moot question arises that whether the property of equivalent value may be attached, where the property derived or obtained from schedule is not held or taken outside. If any property is permitted or held, liable to be attached irrespective of its date of purchase, it would amount to declaring second and third limb of the definition of proceeds one and the same. As pointed out by the Council of the Appellant, the third limb of the definition was inserted on Act 20 of 2015. Therefore, the third limb has been further amended with effect from demand, enlarging the scope. The question arises that if the appraised value of such property and property equivalent to the value held within the country or abroad are the same connotation and carry the same meaning, there was no need to insert the third limb in the definition. Made by the legislature cannot be meaningless or without. Use of the different words in the insertion of the third limb in the definition cannot be ignored or interpreted casually. Every word chosen by the legislature deserves. Accordingly, the word value of such property and the property equivalent to the value held within the country or abroad cannot be given the same meaning and effect. Had there been the intention of the legislature to include any property in the hands of any person within the ambit of the proceeds of the crime, there was no need to make three things of definition. It was very easy and convenient to say any property in the hands of a person who had directly or indirectly at any point in time had obtained or derived property from the proceeds. There was no need to declare property derived or obtained from the proceeds. The legislation had inserted the explanation of the council on the explanation without it to first step. We find some substance in the contention. However, it's right that the entire scheme of them must be read as a whole in its entirety, and every provision should be read in such a manner that it makes other provisions in the scheme open and meet. We cannot be held in equal. The definition of one of the one has to serve notice for the content. Earning or teaching typing. Punishment is convenient. Obtaining quite genuine and explained for may be as per examining important that property is not improper.
Paragraph 35 is more.
In a considered to understand full meaning, second limb of the definition of constitution consumption of content. It is to the any property no
kindly turn to paragraph 35.
So from this definition, one can make out that there are three limbs.
Yes.
The first limb directly connects it from the proceeds of the schedule offense.
Yes.
The second limb, which narrates about the value of the property, it stipulates that a person may very well may receive diamonds in respect to an offense, schedule offense, but thereupon he sells it and obtains cash. Or from that cash, he purchases a house. So the house or the cash would be the value of the property. That's the second limb. And the third limb is if he purchases out of the schedule offense any property outside India or is taken outside India, then irrespective of anything,
Irrespective of the
any
time,
property
Yes.
in India can be
can
attached.
be irrespective of the time.
Huh?
Irrespective of time,
Or time. Any property
any property.
can be.
Sir, वो जो outside country, we can attach inside country.
Yes, that is what I'm.
Value,
Yes,
value दे दो. No, no,
So
Provided I must have a well outside something.
no, no, no. If even doesn't go outside, then also we can do value.
where? How?
So there is, so we can do, we do,
We do.
means
Huh?
we can do, sir.
We can.
No, you can do, but on what basis? Because the words used in the PMLA Act is very clear. Or where such property is taken or held outside the country, then the property equivalent in value held within the country or abroad. Why this abroad has been brought in? Hmm.
Because of the Modi's purpose.
Huh?
Because of the Modi.
Okay. No, there might abroad may be
Abroad,
in certain places the government of India may have the power to attach.
Or-
In certain places, there are relations, there are
There are-
trade agreements to that effect where that power can be attached. So there also you can attach. Maybe today in Dubai you may be able to attach in respect of any property which he has taken to London. So that is depending on your power, which is the government may have in, agreements with the countries. So that is irrespective of when you have purchased.
that was the third
But
one.
there has to be therefore the basis. In order to do that, you have to have the basis that he has taken out some property. And on the basis of that, we are doing this. Isn't that the requirement of having a live link in view of the third limb or the second limb? Because you are saying on your affidavit or here on the value of the property. Value of the property has to be derived from the proceeds of the crime. Either the proceeds of the crime, that is from the scheduled offense, anything happens. Just for example, he has received cash, he has received house or anything. Or in certain cases, he may not have received any pay, but he has transformed that money, the proceeds of the crime, into a house. Then the value of the house, you can do that.
If he means diamond, he means cash came from diamond, and cash he utilized all the cash he utilized. He doesn't have cash now. In that case, we go to his previous property. If he utilized all the cash of proceeds of crime.
Huh?
If he utilized all the cash, means he somewhere he party or somewhere he tour, then we go to property. His property.
Then you go to property means how do you do that? Because that is not all where such property is taken or held outside the country. So are you therefore not required to record of reasons that this particular property or whatever he has purchased out there, he has taken some money outside India or have taken the proceeds of the crime outside India, therefore we are attaching this. Isn't that the requirement for attachment of that 97 property?
That's all. I must have something in the outside,
Hmm.
which they can't attach. So they can attach here. That is the benefit.
If he utilized all the other money, extravagant spending or something like that, he spent all the money.
Even then, he
Then
he
we
said,
go to-
yes, I have spent all the money, so they can attach my previous property. Where from they got I have spent all the money, proceeds of crime. That's not the section 35 logically, paragraph 35 is more.
That
Precisely
I've
with-
looked into. There it has been explained how it is to happen.
There, probably what they want to say. Suppose I have spent all the money with the proceeds of crime. And I have purchased the property.
Then
which is not
also,
scheduled
then
of-
also, are you not required to record your reasons for that?
I have-
You have not done that.
Yes, sir. That reason to believe we should record
No,
how
no.
it is dissipated, how it is spent.
Then in that case, you have to record in order to have a live link that you are saying that he has spent all the money. In fact, the problem arises because you should have taken the actual value.
Sir, I am not sure.
If a person, just for example, I'm
that-
telling you, if a person today in 95 or even in 2008 had purchased a flat out there in Delhi, you are from
I'm from Haryana.
Haryana. So you must be knowing in Delhi or in Gurgaon. If you have purchased a flat in 2008, would it have the same value today? It would go by 3 times.
So we take value of the period of crime.
How can you take the value of the period of crime?
We take circle rate of that time.
No, you can't take the value of the crime because you want to attach why. What is the reason for attachment? The reason for your attachment is this disproportionate attach. Upon being convicted, you will confiscate and forfeit and initiate forfeiture proceedings, and thereof you will sell it off so that you get that amount back. Isn't that the mandate of
Yes, yes.
8.4?
Yes, yes. That is the mandate of the whole PMLA.
8.4 is
8.4, my lord.
Even the
May
trial
the
court
order
can
with
do
us,
it after the conviction.
8.5. Where on conclusion of trial of an offense under this act, the special court finds that the offense of it has been committed, it shall order that such property involved in the money laundering or which have been used for commission of the offense of so and so shall stand confiscated to the central government.
Yes.
Where on conclusion of the trial, so and so finds that the money order has not taken place or the property is not involved, then it shall also order the release. where the trial court cannot be conducted by reason of the death of so and so. So therefore, your basic idea is to get hold of that money, the disproportionate asset. Because here you say categorically out here, Nia, that he had something around 3 crores and his total income was something around 1 crore something. And as such, there is a disproportionate asset of 142. And therefore, very well take that particular 58, it is easier to calculate, and the other 2 to 9 does not meet. So let's take 10 and 11, and then 1, it comes to 142 or more than that, something like
We have to complete the amount.
Huh?
Complete the 1 crore.
That's how the
But
reverse,
safeguard is also
that's
there,
why
my
I'm
lord.
saying it's a reverse engineering.
My lord, safeguard is also there under H6, my lord, where on the conclusion of trial under this, a special court find that offense of money
That's
laundering
a
has not
different issue, ma'am. We are not
taken
on
place,
that,
well, that, my lord, the property
a
is not
conclusion of
involved in
trial.
manner, it shall order release of the such property to the person entitled to receive it.
That's the
That
conclusion of the
safeguard is
trial.
also
by
under
the-
PMLA, my lord.
No, no, that is understood. But madam, you have to understand one thing. I make it very clear. I'm not going to touch on the 2 and 3 properties.
Yes, ma'am.
Make it clear. But as regards 1, this court going to interfere because there can't be a reason to believe in regards to 1 in view of the definition of the proceeds of crime. Then I leave it to you, do whatever you feel like. But one has to interfere because unless in your reasons to believe you have recorded that he has spent all the money and therefore to get hold of this money, we need these properties. You have not stated that. And in fact, that if you state also would not come within the definition of 2U unless you say that there is any other, the value of the money which is being defined out there, which I have seen from the Punjab and Haryana High Court judgment, is different. The value of money is irrespective of anything. If you are not able to get anything from the proceeds of the crime, then the value of the money, which is the disproportionate asset, which he says, can be adjusted from any property. But that prima facie is contrary to the definition of 2U. I give you 1 day. Look into it if you have. Otherwise, this is the judgment.
With regard to property number 1,
Property number 1 has to go. 2 and 3, it's okay. But 1 has to. Unless you come up with it. You have this judgment?
Punjab
Yes. 2020 SCC Online PH 738.
20 SC.
Take another copy of the DD.
Yes.
You take it 1 copy. Read it if you can.
That was already challenged by them, my lord, in the Supreme Court.
It's okay. But as she was only referring to another ordinate bench judgment, so I'm giving her, she was expecting that this court would not touch it, if that is so.
But that was not the case of going into the fundamental.
No, in fact, other aspects we are not concerned. 2 and 3 is okay, but 1. Unless you come within that ambit. Therefore, paragraph 30, in this judgment, paragraph 31, 32, and 35. Read it properly. Or if you have any other judgment, it's well and
We
good.
have, sir, we have some judgment. This judgment has been,
Ah,
yes, sir. Sir, after this judgment, some judgment has come.
very well. So show me then.
Yes.
Give it to us.
Okay.
Give it to us. Give it to us. What is the judgment? Give a copy of it or the citation.
Okay. The
Citation.
hearing having become hearing was inconclusive, for which this court fixes the matter again on 25/1/2026, 24 at the top of the list. You 25. You just come up with this thing
Yes,
as
my
to
lord.
whether you have any case.
Yes.
Records to produce is again returned to be again produced on the next.
Records, lordship can gain on.
Hmm? No,
Record gain all.
you see, it's a headache keeping detained. Keeping the records out there will be a headache. We have a lot of problems. Therefore, we don't keep the records.
Let the council retain the record.
He will come, I cannot if that office is on the character or
Because my reasons to believe is something. I can't say in the open.
Anyways, I remember what has been written out
Yes,
there.
I-
Don't worry that.
The supplementary reasons, man.
No, there can be supplementary.
that.
Oblige, man.
Well,
Apply. Five.
Yes. What is this?
Lordship, it is that excise matter where we had a thorough discussion about when does the incidence of tax arise?
It's a tax or what?
The
Tax
duty,
or
excise
excise
duty. Yes,
Oh, here is a case that he has taken all the permissions for you for destroying,
yes,
and he destroyed it.
Yes.
Now you are saying that question does not arise. You have to pay me the excise duty.
yes.
This relates to 1910 Act, not the 2000 Act. Yeah, everything was done prior to the repeal of the 1910 Act, Assam Act. My lord, what?
So when does the act become? When does the duty become leviable?
Only when it is removed for human consumption or for sale. Finally come to
No,
rule
no, no, no,
41.
no, no, no.
Rule
You are a bonded warehouse.
Fine.
If you are the bonded warehouse, under what is your basis of keeping the property? The excisable goods.
Excisable good has to be paid only at the time when it is removed from the bonded warehouse. Otherwise, the basic
No, no, no.
structure of
Why it is named as bonded warehouse?
because without paying duty, my lord, I can keep it. That is the basic.
No, because you give a bond. Excisability of a good happens at the time when the good is taken from the manufacturer and brought within your confine, and you give a bond that you will, when you transfer it out, you will be, you will see to it that the amount is kept by you so that it is paid to the author.
Lordship, that is just a
My-
manner
my-
of payment.
My
If
understanding-
without notice, a payment
It's
needs
the point.
Yes.
It's the point.
Yes.
It's otherwise nothing to it. It's
Yes.
the point of, what do you call, a point of in taxation law, it is called the point of sale.
Yes.
The point of sale keeps on changing. You see, as per the Assam General Sales Tax Act earlier, the point of sale was with the retailers at one point of time. Then it would change to this
manufacture.
no,
Bonded.
to the bond.
Yes.
So it will be collected from the bond.
Yes.
And the bond will collect it and then release.
In fact, Lordship, there is a judgment which I would like to rely upon.
Mm.
There they have discussed this similar situation. There is a bonded warehouse and the liquor was destroyed by fire. So now that issue, I have given a list of book. The case is
My lord, before
Lordship,
my-
Because I have heard Mr. Singh.
my lord,
I
let me
remember a
clarify-
matter.
Let me clarify that.
Hmm.
May I take the attention of the Honorable Court, text Rule 2, Subrule
Of the,
of the Assam Bonded Warehouse Rules 1965.
where is that book?
It is in the previous act.
Yeah, that I know. The 65. Yes.
Assam Bonded Warehouse Rules 1965, Rule 2, my lord, Subrule 2, Roman 2. What does bonded warehouse mean?
Yes.
Bonded warehouse means the premises or any part of the premises approved and licensed for deposit or storage of the spirits on which duty has not been paid. Now, my lord, the question your lordship is raising that I am to give a bond. My lord, that I have not found in the rules or in the Assam Excise Act 1910 that I have to give a bond. My lord, kindly come to Rule 41. Payment of duty. When I am supposed to pay the duty. The duty imposed on foreign liquor and spirits other than country spirits imported under bond or stored in a bonded warehouse shall be paid before removal from the bonded warehouse unless a bond has been executed for such payment. Manner of payment of duty, Rule 42. When duty on the spirit is to be paid before removal from a bonded warehouse, the payment shall be made into the local treasury. So before I remove my lord from my bonded warehouse, I am supposed to pay the duty. Now, in my
Imported
case,
under bond. What is this bond? Imported under bond.
that is what I was saying, my but this bond has not been defined as to where and under what provision of law any bond has to be executed. But what basically happened under the excise rules of the previous regime, my lord, I was supposed to pay the duty the moment I removed the stocks from the bonded warehouse, either for sale or for consumption. Not till then. So I could very well bought it, keep it in my bonded warehouse, store it, and I was not supposed to pay till the time
Kindly come to your license.
my
License Roman
Annexure 1.
3.
Annexure 1.
No, the Roman 3 of that book. What is that bond I am saying? That is the book.
Any person,
No, that before depositing terms of your license.
Annexure 1,
No. That
rule,
this license which is being given for a bonded warehouse is there. Is the license. After Rule 43,
my lord. Yes.
number 3.
Number 3, that before depositing or indenting for any spirits to be deposited or kept under this license, he shall execute a bond in favor of the Commissioner of Excise for payment of duty at the rates imposed under Section 21 of the Act on all foreign liquor and spirits imported, transported, or all foreign liquor and spirits deposited or kept by him to the said warehouse.
This is the basis on which I am saying. And now kindly come to the duty, payment of duty in the rule. In the act. The act or rule somewhere.
It is rule, but
No. When does the point of the excisability of the goods happen? Kindly come to section 10
of
of the
Assam Excise
Act.
Act.
Yes. Then 1C. This is your point of excise. And because of the fact that you give a bond, you are not liable to pay. You don't pay. That is the basic. Kindly see excise. When you, at the moment, no intoxicant shall be imported unless, now 1C, the duty, if any, payable under Chapter 5 has been paid or bond has been executed for the payment thereof. And now, therefore, on the basis thereof, you execute the bond in terms of that.
And at which part your lordship is written?
10(1)(c) of the Act.
Assam Excise Act.
Yes. You don't know what one into
My lord, this is very fine, my lord. But whether this has to be read thereafter of Rule 41.
Rule 41 is different. Rule 41 will only come into the picture when you are going to put it outside.
So in my case, my lord,
But here is the case you could not put it outside because the rule does not permit that even if the commissioner tomorrow does not permit that in respect of dead stock, what is going to happen, it doesn't say anything. The rules are silent on that.
my lord, 229 instruction is clear that he can exempt. In my case, he has given the waiver exemption. Has been
Where?
given. Instruction to
No, section.
It is
Where
under,
is it that he can waive?
under instruction 229 on which reliance has been placed even by the Commissioner of Excise.
No,
My case,
where? Two?
229, my lord.
Huh?
It is the instruction relating to liquor. The heading starts with this, my lord.
No, section.
This is part of the Act, my lord, and the instruction has originated from the powers conferred on the Commissioner, my lord. It starts with instruction 1. If I can take your lordship.
What instruction?
Instruction relating to liquor, my chapter 1, appendix 3 of the same book.
Page?
Page may be different, my lord. In my book, it is page number 219.
Instructions relating to liquor.
So,
Yes.
my lord, kindly come to 229. Remission of excise revenue.
229.
229.
Yes.
The Commissioner of Excise is authorized to sanction the remission of irrecoverable excise revenue. Application for such remission shall be submitted to him to the district office.
So that is provided that without the sanction of the provincial government, no remission of revenue fees can be given.
Commissioner is the representative of the government, my lord. Kindly.
No. If it is there, then why is the requirement of the proviso?
And lordship, it says irrecoverable. It means that it is completely impossible to recover that amount. It's like writing off a loan, which for a company that does not exist anymore. Only for those situations that can be done.
My lord, kindly come to page 44 of my writ petition annexure 15 when the Commissioner of Excise waived. And this is the provision under which he waived. And this has not been page 44, my lord, annexure 15.
Yes.
The second paragraph, my lord. Therefore, subject to as objection by audit, total excise duty involved on the above sedimented stock of beer against which no revenue is forthcoming.
This is again subject to.
My lord.
And there was an objection.
Now, my lord, I have two things more to add. What has happened along with me, there were two other bonded warehouse who were given the remission. One is Paradise Bonded Warehouse, which I have referred to in paragraph 19 of my writ petition, and the other is Ajay Darpal Bonded Warehouse. Now, they were also given the remission taking account of instruction 229, and no attempt was ever made to recover, and their amount has
On
been
negative
on the same
equality.
count, on the same count.
On negative equality.
Not negative, my lord.
And
I am.
what is this?
My
No,
lord,
first of all, Mr. Singh, we are to look into on the provisions of law. This court is have to look into as to whether in the facts of the case, whether you were liable or not. Yeah, go and file a case, civil suit against this thing, do whatever you feel like, or ask for money. But the fact that how can it be recovered, taking into account you were under a bond.
So, my lord, I will again urge this honorable court to look at Rule 41 and 42 again.
41,
There are-
42, I've looked, Mr. Singh. The 41 and 42 will only come at a later stage. If you, the moment you remove it, then
My lord.
only the payment of
Now,
duty
if I am
comes.
not removing, my lord,
Yes.
and I am praying that it has to be destroyed because it has become non-fit for consumption by human beings.
Hmm.
And it has been destroyed within the four walls of my bonded warehouse, my lord. So there is no question of removing it outside my bonded
You
warehouse.
feel the
Where is the
spirit
question
is
of
paid
imposition of any duty, my lord?
will- Forty-one, what does it say? The duty imposed on foreign liquor and spirit other than country spirit imported under bond or stored in a area shall be paid before removal
Remove-
from the bonded warehouse unless a bond has been executed for such payment.
So, my lord, I am stressing importance on the word removal. Twice it is appearing under Rule 141 and again under Rule 42. Now, my case is, kindly see, Rule 41 shall be paid before removal, and again, kindly see Rule 42, second line, when duty on the spirit is to be paid before removal from a bonded warehouse. Now, kindly consider the situation, my lord. When I make an application that this is the situation of the sum of the quantity of my beer, my lord, which has become non-fit for consumption, then it was sent for chemical examination, and ultimately the chemical examiner of the excise department found, yes, it has become non-fit and it cannot be consumed. Thereafter, the commissioner of excise gives the instruction for its destruction. And the destruction is carried out under the supervision of superintendent of excise within the four walls of my bonded warehouse. It was never removed outside the bonded warehouse. Now, where from the duty can be imposed upon me, my lord? If it has been destroyed, that too within the four walls of my bonded warehouse. So my whole contention, my lord, is that there was never any removal from my bonded warehouse. Where from the authority is getting the power to impose tax or duty, my lord?
The power is there under 10.
But my lord, when there is no removal, whether
No,
it
no,
can
it's
be
no,
paid-
10 does not say on removal. It's a saying, kindly appreciate. It is because of the bond you are not to pay.
very fine, my lord.
The duty, the payment of duty or excitability of the goods happens the moment you remove it from the manufacturer.
No, my
Yes, that
lord.
is why.
Okay, my lord.
And that is why this is the particular difference between a bonded warehouse and a retail warehouse is given now, the wholesale warehouse is given because of that.
Yes,
Now earlier what happens, you can get the air from any manufacturer. Nowadays, this bonded warehouse has to be a part of the manufacturer. Thereby, the moment it comes out, the exciseability happens.
and it is to be paid.
That is the difference
advance.
now.
Now, my
But
lord,
in this case, your excitability happens the moment it is brought, imported.
not under the previous law, my lord. What will
Under
happen, my lord?
no, Mr.
What
Singh,
will
have you
happen?
looked into Section 10?
I have seen that.
You see, the power is on Section 10.
Section 10.
Section 10 categorically mentions that moment it is removed or brought in, imported, you are there's no quarrel with anything. Except if you execute a bond.
My lord, then in that situation,
Then you in that
Irrespective of the-
situation, Mr. Singh, you
Ir-
submit on a different note as to can there be an imposition upon you in respect to certain goods being destroyed with due permission from the authority. When the commissioner was the authority to permit. See, remission question is different. You can't go on the question of remission. You have to go on the question of equity. Can this court exercise its equitable jurisdiction in your favor in that circumstances when the commissioner to whom only you need to apply could have granted you the permission and had granted you the permission and on the basis of which you I think that is the only line left. Not on these provisions.
One more thing, my lord, that is the definitely, my lord.
It depends now on the majesty of the court, not on the statutory provision. Yes, tell me.
that I do agree, my lord. But one thing I would like to add, my lord, that if your lordship sees section 10, divert from rule 41 and 42,
No.
My lord.
This is section 10 is the power.
I understand, my lord.
Mr. Singh, kindly
I
appreciate
understand, my
section 10 is the power, is the charging section.
Charging section.
Whatever else is happening is the procedure.
Only distinction, my lord, I would like to highlight. What does it mean, removal? That means irrespective of the fact whether you remove it from outside the bonded warehouse or not, you are liable to pay.
No. That is was
It
the
should
therefore
not, my lord.
that was the specific condition in your license. You were bound by that license which states that you are normally to pay, but you have executed a bond that you would pay. You hold these goods as a custodian for the government. That is why you are given the power to execute the bond. So your argument has to be on a different.
My lord, then I will confine my argument to the fact that since I applied to the government, my lord, and the authority in its wisdom after looking into the report of the chemical
The
examiner,
only authority who could have considered,
yes,
have considered and then granted you the permission and you have destroyed. Now they cannot do it. On the grounds
And
of
not on-
promissory estoppel or whatever may be, bring something to the effect. This is the only manner in which you can argue. You have changed your position on that basis.
promissory estoppel, I would say, my lord.
Yes, bring
To the-
something to that effect in that manner, not in this manner. This, as per law, you don't have a right. Isn't it, Mr. Bull?
Yeah.
Yeah, he also agrees. See, only manner you have left is that.
I will address argument on that, my lord, on promissory estoppel. Give me an opportunity, my lord. If your lordship is convenient on 5th of February, I will argue on that. Promissory
But you must be knowing
My
when
lord.
you are applying promissory estoppel, there has to be pleadings to the effect.
I have said, my lord, that on their instruction I have done with the due permission, my lord. And my lord, one more thing your lordship said, so for the other two bonded warehouse are concerned.
I don't go into that negative equality. That is for other folks. I am only strictly on this promissory estoppel. You bring up something, but you must know that
I will
promissory estoppel is a question which can be decided if there are specific pleadings.
My lord.
The horse
I
pleadings you cannot, because you have to categorically say, look here, this was not only a promise, this was what has been an estoppel. They are bound by the estoppel which is there. And it is on the equity that they do. Now you cannot
Go back.
Lordship, that's what I would like to point out. The permission was given pursuant to their application because they said that their liquor is unfit, and then pursuant to a chemical examination, it was allowed to be destroyed. And in that permission, Lordship, there was no indication of remission of taxes. It was subsequent to that where they somehow got that order from the commissioner, which was also made subject to audit's objection. But that permission to destroy had nothing to do with remission of taxes.
My lord.
No, but whatever it
thing I
may
would
be,
like-
Mr. Purva, kindly appreciate Mr. Pot. Mr. Potako, one thing happens that if they have applied to the authority, say, look here, this has become goods which cannot be consumed. What to do? The authority says you can very well destroy it. And they destroy it in presence of the authority. And therefore, then can they be still insisted upon clause 3 of their license?
because the transaction has already happened, Lordship. Incidence of tax happens when it is
Understood,
produced.
incidence of tax happened, but the incidence of tax was, this is not a case of purely an incidence of tax. Incidence of tax happened as per 10.
Yeah.
The moment here, section 10 says two things. Either you pay the duty or give a bond.
Yeah.
Now, what are the conditions of the bond? The conditions of the bond is that you give a bond that I'll pay you this amount.
Yes.
And as such, this is the bond I'm giving it to you. That is your terms of their bond.
Yes.
Now, they say that, look here, I have given you the terms of the bond. The bond is there. But that bond cannot be executed or done anything out here because the goods for which I have given you the bond has already become useless. So what do I do? So then you say, okay, we have a chemical analysis report. Let's you destroy it. They destroy it. Now, can you insist on the terms of the bond?
Yes. Because, Lordship, that is the very purpose of the bond. Because
Understood. Can you impose? Then does equity come into the
Their argument was different. My lord, kindly see their additional affidavit.
No,
That,
not
that
this.
will answer, my lord. That will answer, my lord. Kindly see the additional affidavit, more particularly the report of the accountant general on the basis of which this imposition was made. My
Hmm.
Annexer A.
Hmm.
Page, relevant page will be, my lord, page 64.
Hmm.
Kindly come to the second paragraph. It
Hmm.
was, however, noticed that though Chief Commissioner of Excise Assam did not waive the duty involved in the quantity, neither did the licensee pay the excise duty of 36,50,000 to 50 lakh, nor there was any demand raised. This is pertaining to me, my lord. Now, the Accountant General has opined that there was no waiver, and only because of that this has been imposed. The reality is that by Annexer 15, it was remitted or waived, my lord. So the basis, the very base, my lord, is wrong. This is the Accountant General report, my lord, which actually provided the foundation again to impose tax on me subsequently in the year 2018. So if
This
this
is the
report
audit
is,
finding.
my lord,
This is the audit finding.
audit finding on the basis of which, again, the letter was written to me that you pay because the Accountant General is not agreeable. And this report is particularly related to me, my lord. The page 62, it starts, the report of Accountant General, my lord. And it is kindly come to para 2, non-realization of revenue amounting to rupees 2 and so.
Then I read it. You kindly come to paragraph page 64 or 77. During the test check of the record.
Page 64. During the test check of records of Superintendent of Excise North Lakhimpur and Messrs. M.H. Hajarika Bonded Warehouse, it was observed that SC North Lakhimpur on 15th March 2016 had letter dated so and so forwarded a statement to Commissioner of Excise Assam, which was submitted by the officer in charge of Messrs. M.H. Hajarika Bonded Warehouse on 14th of March 2016 regarding 8,693 cases of doubtful beer stock and in said bonded warehouse, which were not in conformity to ISI standard, seeking necessary instruction for further processing of the same. The excise duty involved in the aforesaid stock of doubtful beer amounted to rupees 36,51,060. The chemical examination report of non-conformity to ISI standard of 8 samples of aforesaid doubtful stock of beer was further sent to Commissioner of Excise Assam by SC letter number so and so with the request for destruction of aforesaid stock of beer within the bonded warehouse premises. The Commissioner of Excise Assam, in response to the above letter, instructed in May 2016 the SC North Lakhimpur to destroy the above volume of beer after re-ensuring all correctness. The same quantity of beer was reported by the officer in charge of the bonded warehouse to have been destroyed on 19, 24, 25, 26 June in presence of Superintendent of Excise, North Lakhimpur. Thereafter, my lord, till very later of 30th of August 2016, issued by Commissioner of Excise, remitting the amount has not been taken into consideration by the Accountant General, for which this objection was raised. And looking into the objection, the duty has been imposed without informing the accountant general by the commissioner of excise office that, look, we had already remitted by this letter. This is the factual part, my lord, which has not been taken into consideration before imposition of tax. Thereafter, the accountant general said, it was, however, noticed that though commissioner of excise did not waive the duty, the reality is that it was waived. And that letter of 30th August 2016 was never considered or placed before the accountant general. So, my lord, my humble submission, all the discussion that we are making about section 10 or rule 41, 42, because of this factual aspect becomes insignificant, because this aspect was never brought to the notice of AG. And subsequently, without looking into this fact, my lord, the duty was imposed.
So you are saying that the duty, the impugned notice which was issued to you was only on the basis of this audit observation,
That
which
is
had
what-
not taken into consideration that.
Yeah.
And as such, the matter may be again placed before the audit for taking into consideration as to whether it.
That can also
Yes.
be done, my lord, because that was not considered.
Lordship, I would say the objection was raised because either it is removed from the warehouse or it is destroyed. But whenever both of these are done, the leaker is measured, and that measurement data is also intimated to the auditors. And Lordship, they are auditors, so they will never give a legal basis, but they will their accountants.
Mr.
Yes.
Botago, let the audit to consider as the remission given and as to whether the remission would be in accordance with it, and thereupon take a call, and thereupon the excise authority will take a call. That is the only thing.
Yes, but I would say, Lordship, the opinion of Accountant General is pretty clear, Lordship, that there is no scope for waiver in this case.
No, they don't say that. Did not waive.
Yes. Steps may be taken to realize the
No,
excise.
however, notice that though the AR did not waive the duty involved in the AR, in the quantity, neither did the licensee pay the excise duty, nor there was any demand raised by the authority.
Yes.
So his submission is that the order by which the excise commissioner of excise had given the remission, if it had been taken into consideration, this audit objection would have not been there. And if that is not there, the question of issuance of demand notice.
But it was taken
In fact, this is a type of matter which normally ought to have been taken on a Monday or Wednesday. Such of like it. Otherwise, if we go on the other aspect, it can be very well taken up on Tuesday. Now he wants to render it, relegate it to the stage of Monday.
Monday. In the case of Monday, my lord,
I would say,
and this
Lordship,
affidavit, my lord, additional affidavit was filed only when this honorable court on the last occasion directed them what was the audit objection. Then this matter was placed. Otherwise, that was never placed before this honorable. Kindly see, it was only placed after your lordship direction in the month of now. In my humble submission, my lord, once this objection is carefully looked at, nothing survived, because the very imposition was on the basis of this AD report.
So, Mr. Matago, what is it? Very important question of law you can't discuss.
Lordship, here this audit report says that this purported order of remission was taken into account. Here they are mentioning the letter by the Commissioner of Excise. In the 7th line, letter number LEX 237.
That is 15.
Yes.
He has not taken 38.
Yes.
The audit did not take into account 38. The letter number is 420/2015-16/25. That was not taken into consideration.
Yes, that letter was not taken.
That is his submission. Therefore, he wants to relegate it
But-
to a Monday matter. Yes.
But this order is conditional on objection by audit. That is the very first line, Lordship.
So the audit did not take into consideration this letter. Now, if the audit wants to take it, because you did it,
Yes.
audit is done by whom?
The Accountant General's office.
The Accountant General. They have not done it, taken note of it. Now, if they take note of that, the question may have been different. They may do it, and then you may not raise it.
Perhaps then views of Accountant General may be thought. But in my opinion, Lordship, it is very
Has the
clear.
Accountant General filed an affidavit?
Yes, sir.
This one?
Yeah.
Okay. You do one thing. You file an affidavit. On your view, giving your view on the basis of this particular.
Whether it can be remission.
I'll
Remission
give
will
you
be done on.
1 month so that you can give your audit objection or whatever your views on this taking into account. And thereupon we, if you say that you have changed the opinion or any change of opinion would happen, then only the thing would be. That is the best way. He wants it to make it a
Their
Tuesday
affidavit
matter.
is already there. Their affidavit of AG is already there on record.
That is why
Regarding the audit.
he wants the entire thing be resolved here,
My lord.
not there. Isn't it, Mr. Wood?
Yes.
Because the moment it again I remand it back, then the audit may take another 2-3 months, and then they will do another sort of petition.
Yes.
The instant petition has been filed by the petitioner, challenging the challenging what?
Annexure 60, my lord, page 45.
Challenging the communication dated 12/9/2018, whereby a demand of rupees 36,51,060 was demanded from the petitioner. It is the case of the petitioner that the said demand relates to non-payment of dues, non-depositing of dues pertaining to 8693 cases of beer, which the petitioner, which on becoming not fit for human consumption and also not in conformity with ISI standard, was permitted by the Commissioner of Excise to be destroyed, and accordingly were destroyed in presence of the officials of the Excise Department. The learned counsel for the petitioner submitted that pursuant to the said destroying of the beer cases, an application was filed before the Commissioner of Excise for exemption of the ad valorem levy which was duly granted on 30/8/2016, which is Annexure 15 to the writ petition. In terms with Instruction 229 relating to liquor under the Assam Excise Rules 1945. It is the submission of the learned senior counsel appearing on behalf of the petitioner that a perusal of the audit audit findings which have been enclosed to the affidavit filed by the Accountant General reveals that this very communication was not taken into consideration while arriving at the finding, while opining that the Commissioner of Excise did not waive the duty involved in the quantity destroyed. Neither did the licensee pay the excise duty of 36.51 lakhs, nor there was any demand raised by the authorities for the payment. It is on the basis thereof the audit findings were given, thereof directions were issued to the Excise Department for realizing the excise duty of rupees 36.51 lakhs involved in the damaged stock under the intimation to the audit. It is therefore the submission of the senior counsel for the petitioner that had this document of the Commissioner of Excise been taken by the audit objection, by the audit, the observations so made in its findings would not have been there. The learned senior counsel submits that it is only on account of the findings of the audit the impugned notice have been issued upon the petitioner demanding the said amount of rupees 36.51 lakhs. This court have duly taken note of the said audit findings enclosed to the affidavit filed by the Accountant General. And from the same, it does not appear that the authorities that the auditors have taken note of the communication bearing number Roman 3-420/2015-16 /25 dated 30/8/2016. Taking into account the above, this court fixes the matter again on 4th of March 2024. We make it a Monday matter, no? On 4th of March 2024. The respondent number, your respondent number?
Respondent number 4.
The respondent number 4 shall file an affidavit clarifying as to whether their findings as given would remain the same. No, would clarify on their audit findings enclosed to the affidavit filed by the Accountant General by taking into consideration the communication bearing number Roman 3-420/2015-2016/25 dated 30/8/2016.
Lordship, there's one correction. That additional affidavit was filed by us, where we have endorsed the audit report, not by accountant.
Type of- not of
Additional
excise.
affidavit.
Wherever it is appearing. Wherever it is appearing as a AG, it could be AG report has been enclosed
In-
by Commissioner of Excise.
Excise.
By respondent number
AG,
2.
what does AG say?
No remission can be.
AG has not taken into all these aspects into consideration while submitting their affidavit. AG has given a normal outline view of the entire aspect of the excise matters pertaining to Assam. Not a specific answer to our.
No. Here he says, kindly come to page 61. It otherwise in your book, page 54. No. One aspect is there. Kindly see page 68 of their affidavit. Running page 61 if it is not there. If you order no. Loss of government revenue due to irregular remission of excise duty. In your affidavit, AG's affidavit, kindly see page 61 or 68. You have it, Mr. Bhattakur.
We do not have the affidavit.
You have not been given.
Yes.
Do you have a copy of it, Mr. Of your affidavit?
No.
Or you don't have? मैं extra को file করে নি মুখ দেখো এটা তো ভুলতো না এগো অর্ডার করে দিব না লাগে হ্যাঁ এখন দিদিও This affidavit, Mr. Bhattakur, have a look.
Lordship, is referred to page 61.
Page 68. That affidavit, in that affidavit, there is an audit objection as enclosure. Annexure R1, R41. Have you seen it? Yes, yes, that one. Kindly come to the page, next page. This one, 3.8. You see it? Then come here. The next thing. This is a case of 3.8 is loss of government revenue due to irregular remission. So thereby, the remission aspect has been duly taken note of by the audit. Kindly come here, the next page. Out of 45 unit office in the state audit selected 14 units, 35 out of the 14 units they are audited in 2 units, that is in Jorhat and North Lakhimpur, the Commissioner of Excise Assam ordered the disposal, destruction of unsuitable of so and so bulk litter and so involved the remand of 2 bonded warehouse on so and so, respectively, and out of 8 so and so. Accordingly, the officer in charge were so and so, man respected that his order of destruction of Ivan has been carried out. Audit observed that the excise duty chargeable under so and so was not realized in view of the remission allowed in August 2016
Yes.
by the
That is
so and so executive quoting executive. However, as the excise duty is leviable on the quantity received in store, irrespective of any further loss or account of so and so, treating such revenue irrecoverable does not fall under the excise rules and rupee is recoverable.
Yes.
Then what is the, you have not looked into Mr. Singh with this?
I'm now looking for it.
Yes. So you don't have a case, so you have to dismiss it now.
My lord, my promissory estoppel.
No, promissory estoppel has gone for a 6.
No,
My lord,
I gave you an opportunity of promissory estoppel, but after this, I don't think no promissory estoppel.
no, my lord, whatever AG says, my definitely I have a case to argue on promissory estoppel because what AG, whatever I have heard.
Then
my
I
lord,
will apply it. Oh, I have to write. Okay, we'll have it on Ibu Katiru. This is the matter again on 6th of February 2024 for further consideration.
May it be fixed on fifth, if possible.
If you come, we'll do it on 6th.
Maybe. Method relates to transmission line compensation. Transmission line compensation under Assam Electricity Grid Corporation. Page 15 is a notice. Based on this notice, we have instituted this rate petition.
What is this bill?
Well, this bill was prepared after adjudicated that transmission line is passing through a plot of land belonging to the petitioner. There are some trees and that will damage. And as a compensation, this was adjudicated. Accordingly, check was also issued. At the time of delivery of the check, revenue authority saying that you are not entitled as because some public complaints are there against the petitioner. It is the case.
Show me there.
Okay.
Who is to pay? The deputy commissioner.
Deputy commissioner, yes.
What is the public complaint?
Public complaint, just they're saying, nothing has been annexed here with.
They file affidavit.
Yes,
What is the affidavit?
page 28 there. Affidavit filed within the respondent number 6,
Mala, we have stated in paragraph 4, Mala. Just take it up.
Who is respondent number 3, 4, and 5?
AEGCL, some electric grid corporation.
We have issued the statement.
Yes. That check is returned by the revenue authority.
And what does the revenue say?
It is updated sample. Oh.
What is the name of the petitioner?
Muslim alim.
Your name is not there in this list.
No, my lord, that list is not here. My lord, in our reply affidavit, kindly may have a look, lordship. In our reply, look, page 41, that is my lord survey report. That was conducted
Page?
on page 41, lordship.
Hmm.
41. Survey report, my lord, conducted on 12/3/2019. Check was issued in the year 2021. And now they are saying that this will alert a public competency. Forty-one is the survey report. On the basis of that, page number 42, a bill was issued. On the basis of that bill, check was issued. Check
Check is at page 43.
yes, my lord. Which middle one is the check in the name of petition. Muslim Ali. Check was issued on 12/2/2020.
They say that your name is not recorded.
Lord,
Your name is not recorded in the patta.
no, it is Hasland. Hasland, Lord.
That's in the government land.
Yes, well, they are just possessor. There's the land is there under their possession. Agricultural land.
How do you know that you are in possession?
Yes, well, AEGCL affidavit.
Huh?
AEGCL file.
AADCL's affidavit would not help it. It is the affidavit of the government who will help it. They say that you are not in possession as per the Latman's report.
Lordship, they are relying upon my lord, report on the basis of Manipur circuit. And my lord,
Show me the document under which you can say that you were in possession of that land.
yes. My lord, except my lord, revenue received. Others record is not
Revenue receipt for what? That revenue receipt which you have enclosed
Yes.
is not in the name of your name.
here. Father's name.
It is name of Ali Akbar.
Yes.
From whom taken, for whom taken. That is different land. That can't be a caste land.
Ali Akbar is
If it is a, you see,
Lord.
these documents under no circumstances can be said to be in respect of a government land. At page 47 and 48,
yes.
cannot be said in respect to a government land.
My lord.
Because if it is mentioned out here in respect of for whom received, it is from a person.
My lord. Yes.
If it is a government land, it will be a Tozi Moza.
Yes, my lord. Here there is no tag number, there is no pattern, only PJ. As I mentioned that PJ number. It's called so for my lord, in instruction, there is no
Patta number 9.
that is my lord, PJ is there. So for my instruction.
What is PJ?
PJ means Bedakoli Jorimana. So for my instruction. is concerned.
But they say that you were not in possession.
Yes, well, they are now denying.
Huh?
They are now denying.
And when was your possession taken over?
It's still there on
You are still in possession.
Yes, well, Lordship.
Then in that case, why are you giving, since when you have been in possession?
Well, that is not. That is not. No, we have no instruction.
First of all, that is it.
Lordship,
And this payment
Fine.
of revenue is for the year 2021-22.
Yes,
Why not the earlier period?
earlier period also.
That is the question, earlier period.
There
Now you have paid this amount out there. So and so, does it give you any right on this?
Lordship, kindly may have a look. A affidavit filed by the ADCL. There.
ADCL has no business out there. ADCL is not the revenue authority. First of all, the deputy commissioner's affidavit categorically mentions that you are not in possession of the land. That land is not recorded in the name of you. Patta number 7. This is the document which have been mentioned is the tag number is 7.
7.
7. Tag number 7.
We have stated also the petitioner and his father have no position.
Tag number 7 of Deuteronomy Part 1.
Yes.
Now your document which you have enclosed, is it in respect of tag number 7? No. Then
No.
Well,
how does this have any relevance? If the payment was made in respect of tag number 7,
Lordship, just one. Well, they are relying upon report submitted by the Manipur Circle. And survey was conducted in assistance with Circle Officer Disney. And Manipur is a new circle office bifurcated from Disney office. So, so for my instruction concern, it is happened to be changed,
Huh?
Happened to be changed,
it happens to change or anything, you are asking for a writ. It's your duty to show that you are in respect of tag number 7. Where is tag number 7? Show me any document as regard tag number 7. This amount was paid for tag number 7.
No.
Isn't it? Mr. Kutoki?
But in the presence of my locality concern, my circle officer, survey was conducted. ADCL was there. Thereafter, my survey was conducted, report was prepared, check is issued. Now they are disputing that you are not entitled. In the presence of locality, nobody will saying that they are not in possession of the land. Just saying that the public complaint is there.
Not public complaint. They are not only saying that, they are also saying out there
that
you are not in possession of tag number 7.
My lord, we are admitting there are laymen, nothing has been on their record. Khas land, my lord. As a orally, Mondal said that your tag number is 7. They are also, as we asked them, they are also said that the tag number 7. My lord, it has happened to be changed, my lord.
It has happened to?
Well, a new circle has been created, bifurcated. So, well, it may be happened.
It may happen when?
Well,
when was it created?
Well, there is still possession.
You are an entire basis of your claim is on the basis of this letter, nothing else.
Yes, ma'am.
That letter does not give you a right. It even does not say which tag number.
That is not mentioned. Only they are only basis on the
Then and why you have not shown any document to the effect showing that you have paid any amount, and why the payment has been made in the name of your father and you are approaching this court?
Land divided in parent and son, and revenue paying by the father. Yes, Mallet.
Go before the civil court. Ask for money there. Better off. So prove your thing that you are in possession of that and you get the money. Better off. You can't give this because of when they say that you are not in possession, they say that your name is not, obviously your name would not be recorded. But more apparently, they are referring to dark number 7 and you pay somewhere in dark number 9.
Right, yes, my lord.
How will this court decide all these things? Tell me.
My lord, we are only on my lord, that bill, my lord. That bill was my lord, prepared.
That
after
bill
my lord.
is being prepared by them, whatever may be. That does not give you a right over the land. You have that, very well, go there. No way out.
Yes, my lord. Then my lord, we are withdrawing.
The instant writ petition has been filed by the petitioner, claiming an amount of rupees 1,96,452, along with interest at the rate of 14% per annum. In respect to the acquisition which amount pertains to the compensation relating to construction of the erection of the line by the Assam Electricity Grid Corporation Limited. The petitioner in the instant case was issued a notice under the Indian Electricity Act 2003 on 2/4/2019, wherein it was mentioned that the petitioner would be entitled to an amount of rupees how much?
My lord, 1,96,000.
1,96,452.
Yes.
However, the said amount was not released to the petitioner. And upon inquiry, the petitioner could come to learn that the said amount was not paid by the district administration on the ground of some public complaint. It is under such circumstances that the petitioner had approached this court by filing a writ petition seeking the reliefs as aforementioned. This court have also taken note of the affidavit in opposition filed by the respondent number 6, that is the Deputy Commissioner. Which one?
Right.
Where?
My lord, Sister Bongaigaon district, my lord.
Bongaigaon. Wherein it is mentioned that the land in question pertains to dark number 7 of village Devtori, part 1, wherein the petitioner's name is also not recorded, as well as also on field verification, it was found that the petitioner was not in possession. It was therefore mentioned that under such circumstances that the petitioner was not released the amount of rupees 1,96,452, although the check was sent by the Assam Electricity Grid Corporation Limited. This court have also taken note of the affidavit filed by the Assam Electricity Grid Corporation Limited, wherein also it has been mentioned that according to the estimates given by the district administration, that the checks were duly disbursed to the circle officer for onward payment. However, the check in respect to the petitioner was returned. This court have also taken note of the affidavit in replies filed by the petitioner to both the affidavit in opposition filed by the AEGCL as well as the district administration. In the said affidavit in reply, it has been mentioned that after due verifications conducted, the notice dated 2/4/2019 was issued. And thereupon the check was issued by the AEGCL authorities of an amount of rupees 1,96,452. It was further mentioned that the petitioner was issued a notice by the Circle Officer Bizni on 8/4/2021. And the petitioner duly appeared, but thereupon the amount has not been paid. Further to that, there is an enclosed, there's a document enclosed. Further to that, the petitioner have also enclosed 2 revenue receipts for the years 2014-15 and 2021-22. However, a perusal of the said revenue receipts shows that the said have been paid on behalf of one Ali Akbar by one Noor Islam. And the same pertains to 9 number BJ of an area of land measuring 5 bighas, 2 kathas, 12 lessers. This, however, does not tally with the affidavit filed by the respondent number 6 to the effect that the land in question pertains to dark number 7. The above, therefore, clearly shows that there are certain disputed questions of facts which can only be decided in an appropriate forum where such disputed questions, such facts can be adjudicated. This court is also of the opinion that, taking into account the above, and this court is also of the opinion that these intricate details, intricate adjudication of facts cannot be made adjudicated upon in a proceedings under Article 2 to 6 of the Constitution. Under such circumstances, therefore, this court is not inclined to entertain the instant writ petition under Article 2 to 6 of the Constitution. Be that as it may, this court, however, grants the liberty to the petitioner to approach the appropriate forum and the non-entertaining of the instant writ petition and the consequent dismissal of the instant writ petition would not prejudice the petitioner in such proceedings if so initiated by the petitioner. Further to that, taking into account that the petitioner had been bona fidely litigating before this court the period from 27/7/2021, recorded the date of filing of the instant writ petition, till today, be excluded while computing the period of limitation. With the above observations and directions, the petition stands.
Supplementary item 14 particular.
Here we were supposed to file an affidavit today. The affidavit is ready. The petitioner, he was on his way, but he got stuck due to some traffic congestion. Some Bharat Jodo Yatra is going on with their Kanapur. We are filing it today, madam. And can it be on Friday, Thursday next, the day after tomorrow, madam?
Now tell me, did you file any objection
Yes, yes.
against those
Yes,
two
yes.
IMFL?
Yes, the second, against the second one, the objection were filed. That we have annexed in the affidavit, madam. It will be on record, madam. We can. The affidavit is otherwise ready. Whereas for the signature, objection is here. Pilot, we should take it.
Then what happened?
Pardon?
What happened?
No, my lord, we are not being able to file it because the petitioner, my lord.
Understood. You have filed objection.
Yes.
What happened to those IMFL?
But in spite of the objections, my lord, the third,
What about the other two
they are running
IMFL?
along.
You have filed objections or no?
Yes.
Yes. Now, after filing objections, what happened?
So they were instituted, they were set up.
Then what did you do?
Again, the one after the first two were in set up, my lord, they were again trying to set up one third one.
This is the third one.
No. Again, earlier there was other round of litigation, my lord, by the people of that this house, and that order we have annexed, my lord, in the petition. And in that petition, the government, what they said, they shifted the points of to some other place. That is apparent from the order.
Then
Then again, the third, again, they have.
this one has come.
This one has come.
So you were a party to the earlier writ petition?
Not a part.
Why?
There, some other person was litigating.
So did you raise any objection against those IMFL off and on license?
The instant petitioner was not there, madam.
No. As regards the other two
Yes.
IMFL off and on licenses, did you agitate against the authorities before the authorities?
Yes.
You filed objection against. Then what did you do thereafter?
Thereafter, well, the third one.
Now forget about the third one, 1 and 2. What about the 1 and 2?
One was already there.
So have you raised any objection?
Against the second one, objection were raised.
You raised or not?
Yes.
Then what happened?
Then,
Nothing.
nothing.
Then did you file a writ petition?
No. Yes. We have annexed it, the order.
That is against the third.
Yes.
Which was then the government removed it to some other place.
Yes.
I'm saying about the number 2. Did you file a writ petition? Because here we are concerned with the bona fides. We are concerned about the person. Yes, we are concerned because here is a case of one person objecting would not do.
Yes.
Here we have only one person. Neither there has been any, yes, maybe one person can very well file for the others, but then also if there is some resolution taken, we could have very well entertained that.
Resolution was there, my lord. We could not annex them, my lord. But in the additional affidavit that we are filing, my lord, there we have annexed the resolution.
Of those persons
Yes.
who have authorized you and the other person to file a petition.
Yes. Now again, latest, my lord, as the second petitioner, my lord, he sought to withdraw from the petition, my lord. So now they have authorized the petition number 1 to.
When?
My lord, recently, my lord.
No, not recently.
Because-
Prior to that.
Okay.
Prior to filing.
Prior to filing is there.
Prior to filing, there was a resolution.
This is in vernacular, madam. I repeat. These documents were annexing to the.
I give you 1 month's time to file your file your affidavit, but these people's addresses also may be put. This court, by an order dated 12/1/2024, had directed the state the petitioner to file an additional affidavit. However, the said additional affidavit was not filed. Taking into account the above, Mr. P.K. Muni, the learned counsel for the petitioner, submits that the additional affidavit is ready, but could not be filed in view of the fact that the petitioner could not come to Guwahati on account of such a personal inconvenience. So taking into account the above, list the matter again on 11th of March 2024. We are in Riyana? No.
January.
On 5th of March 2024. Pustak.
May I pray for the continuation of
No. Not in paper. Not satisfied with. You have to give the name to persons and address,
address along with the
because any person can sign.
each and every person.
That's why the rule 75
Each
meters.
and every person who has signed it.
My lord.
That's why the rule 75 meters has been introduced.
And as to whether
For a moment, these objections were filed on 2014. But at that time, these rules were not available, were not in force, because these rules came into force only after 2016.
I'm not on that.
First of September.
I'm not on that. We are to take note of today. Now, under such circumstances, those persons who signed it, if you are putting that document, their addresses has to be, and it is going to come before me.
Right.
Obliged, Lord.
This is regarding the corpus fund scheme.
Yes.
My lord, is the copy of the official email, lord, where the instructions followed by your lordship reflect. The very next page.
Please find very contact. Right. Let us see that list.
Yes,
now.
my lord, page 87.
There were 10 persons. Na?
Yes, 2 were absent, 8 were evaluated. Interview was taken of 8 leading.
Who had opted Madhumita Dwara,
Yes, that is serial number 5, man.
5, Pratibha Mohanto,
7
and
and
Urmila
10
Rabha,
who was absent. 10 was
number 10. And the petitioner is
petitioner is Jutika Roy, serial number 4. Now, rank wise, my lord, rank wise, Madhumita Dwara is 5th.
Huh?
Rank wise, my lord,
Uh,
Madhumita Dwara is 5th. That is serial number 5 is 5th.
5th.
Pratibha Mohanto is 3rd, and she was shortlisted.
Hmm.
And Urmila Rabha was at.
And that Urmila Rabha is
She was at. So much.
so that is not there. So who got it? 38.
my lord,
Deepshika Sinha.
yes, Deepshika Sinha was recommended. 2 Mosumi Das, serial number 6 was recommended, and Pratibha Mohanto, serial number 7 was recommended. And Jutika Roy, she her number finds place at 8th rank. This is the last score making category. And because of the state of the records, my lord.
Now in the affidavit file, 4 applicants out of 10 applicants opted for corpus. All the candidates were evaluated for 40 marks because marked under the head capability of AI, capability. Since the mark on the land has been considered for all the candidates to make asking the fresh land documents from a particular after interview of nominee. At this juncture, only three names of only two names of serial could be asserted of the topic. Subject to the good point. The then
This is the impact.
where is the termite one?
The termite one could not be taken out.
No. There are attachments. Where are these attachments?
These attachments, I have checked them, my lord. These are very bulky attachments, and those attachments does not pertain to any of the persons, my lord.
No, it is to Jutika Roy.
Yes, Judicial is the petitioner. He is the petitioner.
So its attachment is there. You forward it here. We'll see it here. Forward it. Yes, what do you have to say?
My lord, my story, the matter may be passed over for time being, my lord.
Why?
Previous story is lacked in code number 26, item 40. For time being, my lord.
He can come after the order is passed.
For time being.
After the order is passed. You don't have a case.
My lord, for time being.
You don't have a case. Where is the clause, guideline clause? Corpus fund one. Infrastructure, yes. Internet nakalagay. Yat sabon mo yun. Aile. The application wouldn't be much. Okay, we'll take it after some. Yes. Let's take up Mr. Mishra's matter.
For time being.
Yes, that day also you were waiting. Let's take up your matter. That's the GMDA matter, na?
Yeah.
Yes. What was the item number?
Item number is
10. Ask Mr. Nayak to come.
No, the matter is very short, your lordship, about that. Page number 72, if my lord. Page number 70.
Yes.
In exercise of the power conferred by subsection 1 read with subsection 3 of Guwahati Metropolitan Development Authority Act 1985, it should have been section 3. The governor of Nagaland, Assam, is hereby pleased to declare Greater Guwahati Master Plan area as described below, and that they have gone beyond the provision of section 3. So that will kindly take up PMLA Act. I can keep ahead.
Declaration.
Yes.
The state government may by notification of the declare the area covered by the Guwahati Municipal Corporation and any other area contiguous to the municipal corporation to be Guwahati for the purpose of
We Guwahati metropolitan area. If you lordship will see, there is nothing like Greater Guwahati Master Plan area, as mentioned in page 72.
Okay. So your submission was, if I remember correctly, as per section 3(1), only those places which are contiguous to the Guwahati Municipal Corporation area
Yes.
can be made a part of made the Guwahati metropolitan area.
Where they will exercise jurisdiction as per section 4.
But they cannot do so in respect of any other area which is not contiguous to. That was the submission.
And as a result, what has happened?
Hmm?
The area, as a result, what has happened? Because if you lordship will kindly see 72 once more, see the area that they have
Yes.
covered. Guwahati Metro revenue areas included in the final master plan for Guwahati. Guwahati Municipal Corporation, North Guwahati Town Committee, other revenue areas as shown below. And if the option has this, even here. Okay. Yes.
Yes.
The lottery will take part 1 at page 20, clause 4.9.
Yes.
In modified
20, that's a map.
next before that, the previous 4.9 industry.
4.9. 4. Yes,
Yes.
industries.
Yes. In modified final master plan for Guwahati 2001, 1375 hectare area was reserved for industrial use, of which around 520 hectare area have been developed. Besides this, in also 400 hectares of area is proposed to be developed for industry. In the new town 2, in the northwest, and SCG measuring around 541 hectares supposed to be developed in the town 3 in the southwest, which will also include industrial activity. Now, if my lord will kindly come to page 89. 89.
Yes.
Now, at page 88, table 11.3. Number 2, New Town 2 special scheme area. So this has gone up to Swalkuti.
Yes.
And below that, New Town 3, it has gone up to Tarapatipara area. So So they have, because they have extended the jurisdiction, they have taken the industrial area from the existing place to other place, Contiguity area. And the existing place has been made as composite area, where they have spared the industry. The existing industry will remain there. I can show it from there later only. Now, if the Lordship will kindly see at page 38
Of the writ petition?
of the writ petition, my lord. Page 38.
Yeah.
This is a letter sent to us by Guwahati Metropolitan Development Authority in response to our protest that one commercial building is coming up. This is an industrial area. They have replied in inviting reference to above, it is stated that NOC for construction of commercial office building was issued by so-and-so in favor of the so-and-so. As per existing master plan, zoning regulation, Guwahati Metropolitan Area 2025, under provision of the existing building bylaws, hence a prayer to stop construction, violated so-and-so cannot be considered. They have made it a composite area.
And this, you have raised the objection in which area? Where is your communication?
My lord, I'm in planning unit 5.
This is in reference to your communication dated
Yes.
25/3,
That's
25/5, 2013.
That's right. I'll take a look at that. This is at page 35. We have 10.
Poshim Boragaon,
Yes.
Moza, Jalukbari, Guwahati.
Hello.
It has been classified as an industrial area by the government.
That goes by 1986 industrial area, regulation, master plan zoning regulation for 1986, which was a revised plan. Your lordship have this, if your lordship.
Now this Poshim Boragaon
Yes.
is now what, composite?
Is composite. Yeah, I can show from here.
But that day I was taking up another matter. They were showing Poshim Boragaon as eco-sensitive.
No,
That is another matter I've taken up.
Yes, sir. Then even industry cannot be there.
They are showing it as eco-sensitive and
Yes,
eco-friendly.
Yes.
Poshim Boragaon.
Now they're changing.
And that is as per master plan, that is what they have taken.
Yes.
When I fixed that matter? On 8?
On 8th of February. 8th of February.
8th of February. Mr. Mishra, should I fix this matter along with that? Because that will have there they are saying another thing. They say that this is an eco-sensitive zone.
Yes.
If this is an eco-sensitive zone, my question out there, in that case, there were a lot of, that was a case of godowns and all.
Yes.
And in that godowns, they were trying to demolish on the ground that it is a eco-sensitive zone and because you need a special permission for that.
Yes.
For construction, and there is a limit for construction.
Right.
And that if we see this more particularly this book, kindly come to
Phase 3 may not come.
no.
Phase 3. Classification of land use zones.
It be
Phase 3. Part 2. It is part 2. 3. Oh, sorry. We are giving it.
Yes, yes.
Now,
Yes, sir.
we are here, my lord, 9.
Ah.
Composite use.
Now kindly come to 6, page 6.
Yes.
Here you see now note all existing non-issuance, non-polluting uses to continue in the following use zones: residential, commercial, industrial, public, semi-public, composite, composite one. All existing non-nuisance, non-polluted uses may be allowed to continue, discontinue after an application for special permission to the area in the following use zones: recreational, so and so, eco-sensitive and eco-friendly.
Yes.
Now they are saying out there in that case that it falls, this Pusim Boragao falls in eco-sensitive or eco-friendly. So I've asked the commissioner to file an affidavit in that regard. Not the commissioner here, the commissioner and secretary, government of the principal secretary, to file an affidavit as regard. And if this is the case, because if this is the case, they are saying on the other hand that they are in a composite.
Yes. 9, serial number 9 at page 3 in that order.
Serial number 9. And is this Anupam Kakoti is a party into the proceeding? He's a party. Who is appearing? Nani is appearing for you? Because on the last occasion, you submitted that the difficulty which you are being faced is now as regards the challenge to the master plan is on the question that if these areas are being brought in, more particularly your industry is where?
My industry is in unit 5 area, which was earlier industrial.
Now,
Industrial-
what is the area? Exact area?
That area,
West Borough. Paragraph 18.
13.2 at page 3, if your lordship will see. Of part 2.
West Boragao.
Part 2.
Your industry is in West Boragao.
My lord, my industry is situated in near Jalukbari area, Boragaon.
West Boragao.
And
Yes, yes. It has been carrying on its principal business from the aforesaid area covered by dark number 241 of Iman of village West Boragao under Moza Jalukbari in the district of Kamrup Metro. West Boragao.
And this now they say this is a composite state. Composite use zone.
Now your fear is tomorrow if there is any further changes.
I have to explain out there is no scope for me to further expand the industry. Because they have changed now only existing area. Your lordship will kindly see page 3 of part 2. Part 2.
Yes.
13.2 classification of land use zone. Your lordship will come to 9. Composite use zone 2 includes residential, commercial, public and semi-public and existing industry. So because of that, I'm safe till date. But future extension, everything is flux for me.
But why are you aggrieved with that Posim Boragao aspect?
Because it's not within the municipal area. And it's not contiguous also to municipal area.
No,
and
but why are you against Pasim Boragaon aspect? You have nothing to do with Pasim Boragaon
my lord, my industry is situated
at West Boragaon
and
or Pasim Boragaon.
well, it's Paschim, industrial area at Paschim Boragaon.
West Boragaon is Pasim Boragaon.
Yes. So, and the ground is, my lord, that section 3(1) notification is one without authority also. If your lordship will see,
Now, Pasim Boragaon was initially not contiguous to the GMC.
no, but no. It
Why
was
do you
not.
say so?
Why I'm saying, my lord, because this was an industrial area under 86. Earlier it was not there. And 86, this master plan was under Town and Country Planning Act, not under the Municipal Corporation, GMDA Act. If your lordship will see the first page only, the notification dated 25th September 1986. This is under, my lord, in exercise of power conferred under section 14 and subsection 2 of section 10 of Assam and Country Planning Act 1959. So under Country Planning Act, the entire government can exercise jurisdiction throughout Assam. But under the GMDA Act, they cannot, because GMDA cannot go beyond the provision of GMDA Act, that is 3(1) and 4. And your lordship has seen the notification. Now suppose, my lord, Swalkochi they had not taken. Then the industrial, that could not have been declared an industrial area.
So you say that Pasim Boragaon is not contiguous to the GMDA, to the GMC.
Yes. Yes. In fact, my lord, I wanted a notification to find out, to see if what were the areas declared by the government as GMC area. And then what would be the contiguous area? I couldn't get.
And how do you define the contiguous thing?
Contiguous, melody, contiguous, the whole country is contiguous. Contiguous is which is within reach. So far as the election is concerned and the limitation for election under section 42 of the AFC Act, that they have extended because they have so many constituencies and so many councillors. But I wanted a specific notification to see what were the areas included when this 1972 notification came.
Because the word used out here in the air, this act is contiguous.
Contiguous. Yes. Contiguous.
Or
Now,
any other area contiguous to the Guwahati Municipal Corporation area.
Yes, yes. Now kindly see, in the notification they have included even North Guwahati Town Committee area. They have gone areas which were never in municipal corporation.
North Guwahati Town Committee would be next to across the year, but
that will not be contiguous in any case.
the river would
Yes, but contiguous is adjacent. Otherwise, everyone, your lordship will go or everything is contiguous to each other. That way it cannot be extended. It is nearby area.
And I think the GMC in your place, as of now, there is no GMC.
No GMC.
No GMC.
I'll have to have a
No GMC.
No.
There's no GMC beyond this, what you call the highway. Because Pasim Boragaon is beyond the highway.
Yes, but GMD is there.
GMD is there. That is the issue.
Not.
Beyond the road, highway, there is no, I think on the other side of the highway, you have the GMC.
This Paschim Boragaon area is on the other side, but GMC is not there.
This side, it is not there.
No.
The across the highway, the other side, Just for example, Posim Baragaon, the across the would be that area pertaining to.
The Pomahi area, they have their.
No. Pamui is this side. The other side would be near, just in front of something in front of the Remission Hotel, just in front of the across the area, across the national highway on the other side. Would that be the GMC area? It will be on the backside of the Maligaon.
Maligaon is otherwise within the GMC.
It will be on the backside of Maligaon. So you take that route out there, no? Sometimes.
That area I was.
So therefore, the word contiguous is the meaning.
Contiguous, in my understanding, Lordship, it's sharing the same word. In a place, Lordship, where I am located, that may not be adjacent to the GMC boundary, but the area, entire area, whole area is adjacent to the GMC boundary. Then also it becomes contiguous.
Or you may say that it may not be contiguous, that if there is a GMC area and there is another area in between, and thereafter the other, you can't make the other area as contiguous unless it has a connection or adjacent.
That connection is here. But Lordship, in my understanding, this is a subsequent improvisation. In the petition, Lordship, basic grievance is that as no declaration was issued under Section 3 of the GMDA, so GMDA is not exercising its power under this is not a power under the GMDA. And that is why that 1992 Act could not have been issued by the authority. That master plan could not have been issued by the GMDA authority. That was the basic
That is
grievance law.
still there.
That area contiguous or not, Lordship, that is improvisation, in my humble understanding.
Your Lordship may take it up as your Lordship desires. But on 8 and 9, my Lord, I have any day after that.
It's okay. You see, you are now challenging what?
My Lord,
You are challenging and
Challenging that 1992 notification, Lord.
Declaring the greater shall be the greater manner for the purpose of God. You are written and directing to 16 and 40 from giving effect to the notification.
Paragraph prayer 3 is relevant.
Right. But that notification is there.
That is understanding. That is understanding.
Understood, but
Yes.
without if that till
According to the petitioner lordship, this notification is inconsistent with section.
no, understood, but till the notification remains is not set aside, the prayer tree does not have any value.
Yes. So that requires adjudication whether any declaration has been made under section 3 or not.
If it's a declaration made, they may say in that tree, but whether.
According to the petitioner, no declaration, no such declaration is there.
But you have not asked for anything against the other party, no?
Other
That
party-
Anupam,
Yes,
what you
yes,
call?
I have,
No, there is no relief sought for.
my Lord, we have said given after.
No, there is no prayer.
No, there's no prayer specifically.
And there is nothing again. That is why we don't see the other side.
There is point number 4.
Okay. So if we hold that it is contiguous, the matter ends. The question is as to whether it would be contiguous. And what is the meaning of the word contiguous?
But 172 cannot survive. 78 the notification, 2392 at page 72. That is on the face of it without the authority of law.
Why?
Because First of all, it is supposed to have been made under section 3(1) of the GMDA, which does not contemplate declaration of a greater Guwahati master plan area. It says Guwahati metropolitan area. This is number one. Number two, they will exercise powers under section within the area, which is under the GMC area or county. They can exercise. But when the notification goes, because see the effect, because of this illegal notification, they could extend the industrial area to Solkuchi, up to Solkuchi. They could not have done it legally because Solkuchi will not come under that. Now, it will have an effect. It will have a cascading effect on us because if the notification by which PMDA was authorized to exercise power under subsection 1 of section 4, they could not have reached GMD area and industrial area could not have been shifted. But because their power and jurisdiction was extended, they could shift this area. Otherwise, the areas would remain where the industries will go. So therefore, this will have to go. 72, it is not in consonance with subsection 1 of section 3 or section 4.
But here, if we read simply section 3(1),
yes,
it states that the state government
yes, Lord,
can, by way of a notification, declare the area covered by the Guwahati Municipal Corporation area
yes,
and any other area contiguous to the Guwahati Municipal to be the Guwahati metropolitan area.
yes. Now, my Lord, can you see? Therefore, 4.
Yeah.
As soon as maybe after commencement of this act, the state government shall, by notification in the official gazette, constitute for the purpose of this act an authority to be called Guwahati Metropolitan Development Authority. Hereinafter refers to authority with jurisdiction over Guwahati metropolitan area.
Yeah.
So now they cannot exercise this power under this notification because this notification gives number one, Greater Guwahati Master Plan area and the areas which could not have been, which will not fall within the municipal area or contiguous area by any stretch of imagination. Those areas have been included, my lord, in the GMDA area. So therefore they have, it's a cascading effect. So therefore this is an illegal notification.
This notification is not entire, the entire notification is this?
Yes.
Page 72?
No, my lord, we have given separately, so not typed properly. Given a copy with the paper.
But in this notification which you are referring to,
yes,
where is Paschim Baragaon?
No, it's not mentioned. Other is not mentioned. Maybe they say it comes under Guwahati Municipal Corporation.
No, if it comes under Guwahati Municipal,
No, I'm saying they may have thought.
no, but there, if it is not within the area of the GMC, how Paschim Baragaon?
That's one question.
Have you looked into it? Here,
I can give
you are having those areas in the GMC. No problem with that.
Yes,
GMC area is okay. But the other revenue, not Guwahati Town Committee you are putting it, it's another aspect. Other revenue areas as shown below. These are the villages. Rudresa, Goripur, Bhoypur, Tilingao, so Goravan,
not Guwahati.
Aminda.
These are all
So
not.
this is not one. Then Ubonsa, Dokhin Rani, Ramsoroni Moda, Borja, so Tharapur, Koralgaon, Mirzapur, so Mikirpara,
These are all exempted.
then Beltola, Bokisto, NC, Danimuna, so Man, Arguli. Then Praktitipur, Arguli, Bonda, where is Pustimbora? Pustimbora is a revenue village.
Yes.
That way they have gone up to Swalkuchi, that is also not there.
Huh?
They have gone up to Swalkuchi area, which I have shown to you lot. That also is not mentioned here.
Nice.
Huh? Village is Pustimbora of Jalukbari Moja.
Yeah.
Now here you don't have Jalukbari. You have Jalukbari Moja. Where is Jalukbari Moja? Does it fall within GMC?
No.
Then how do you exercise jurisdiction over Pustimbora if it is not there in this notification? Take your instruction. It will have a
Basically three areas are here, Lordship. One, Guwahati Municipal Commission, Corporation, North Guwahati Town Committee.
and other areas as shown below.
shown below.
Now here you need to have this. It is under Jalukbari Moja.
In that case, it has to be within a GMC area lot.
Either whether Jalukbari Moja falls in
That
GMC.
yes, that instruction I have taken.
Get your instruction, because if it does not fall, then it goes out.
GMC.
Oh, I have a copy of it. List the matter again on. When can you do it, Mr. Mishra?
Any day after 9 minutes, any day. 12 I can do it.
13.
12, 13 also.
Is the matter again on 13th of February 2024, on which date Mr. Pinag, the learned counsel appearing on behalf of the GMDA, shall apprise this court as to whether the matter and as to whether the land, as to whether the revenue village Pusimboraga is included within, in terms with the notification dated 23/3/1992 issued by the state government in exercise of the powers under section 3(1) of the Guwahati Metropolitan Development Authority Act 1985, or is there any other notification issued? This matter has been specifically endorsed to me. Why?
It was first heard by your lordship.
Understood, but there is a...
Then it went to the other court. The other court, I pointed your lordship's order. Then he said, no, let it be
He
taken.
may be allowed to leave the matter.
If it is made faster, it will be.
Now there's a judicial or administrative order taking this matter to me only.
due to Mondir was damaged. Three persons opted for corpus fund, but the Act number headed discussion they are not opted for. My lord, in the petition, in the writ petition, kindly see para 37 to 41. My lord, in guideline 9B, it is conference was always available only for those candidates who are opted for corpus fund. But I am not opted for corpus. That my candidates may be opted for land document. Other two parameters my document. And my lord, in advertisement, please kindly say. So kindly say in parameter in advertisement 7A. 7A, it is in 7A, 7A, advertisement 7A, 7A, individual candidates included partnership is capable to provide land and investor facilities, 35 months. But in guideline, it is not mentioned. It is mentioned in capable to provide investor and facility, other facility. The land facility. All candidates, discussion or others, all they are not opted for corpus fund. It is totally vicious, bias. As such, this honorable court are pleased to get interim order. Exercise to maintain. If it is as per law, my lord. It is under to look and speak of matter, my lord. It is mentioned only include 40 marks, my lord. But 60 marks is not done. In the record, my lord, it is reflected that it is enacted that due to Mondir was disturbed, some documents are disturbed. Only it is from that three candidates are opted for corpus fund. How can Deepshika Singh or other if other are opted for corpus fund in the clause 9B, it is totally invasive, totally reflected that who are opted for corpus fund, they will be assessed, my lord. They will be assessed as corpus fund. But Deepshika is not opted for corpus fund.
Arda, you did not give the judicial thing to him. You only gave the Asta Jain to him. Why didn't you send the number 3, Jutika Roy, petitioner? Jutika Roy.
My candidate would be considered on another two parameters, not on the interest, because I didn't apply on the petition that I opted for corpus fund. Deepshika Singh's father is DFO.
So she did not apply for corpus fund.
Because he did not apply for corpus, how he ranked on? And it is in basis in kindly 9B. It is there who opted for corpus fund would be judges under corpus fund. There are no need to special other land, other facilities. In the advertisement, para 7A, it is clearly indicated that capable to provide land and infrastructure facilities 35. Then, but in the guideline, it is land is not mentioned. Fine. But in guideline, it is not mentioned. I am to be judged under other two favors, land facility. I have submitted my application with land document. Well, kindly see, I consider my lord.
Mr. Dwara, what is your mark?
26.18. It is
30.16.
Huh?
30.16.
Madhumita Dwara.
Yes, ma'am.
You sure?
Yes, ma'am. 30.16. 30.1.
3.1. And Pratibha Mohanto,
Pratibha Mohanto is
32.
30.83.
30.83. And the petitioner is
Petitioner is number 4, 26.18.
13.
out of 40 pass, my lord.
118.
Land document is not considered, my lord. Why, my lord? Why, my lord? It is not indicated. It is not reflected in the class 90, my lord. It is clearly indicated that who are opted for corpus fund, who are above 40 years, non-earning, widows, SC, ST, they will be available corpus fund. Will be indicated in the petition, my lord. But I am not opted because my either it is
Mr.
indicated.
Counsel, listen. If you had got marks above this corpus fund, people, in these 40 marks, then I would have considered your case. You have got less than those who have got the corpus fund. So your thing cannot be considered.
Land good is not considered, my lord. I am not opted. My lord, I am considered and the other two parameters, my land good other parameter. It is indicated, my lord. Kindly peruse the clause 9b, my lord.
Yes. What is your name? Your name?
Yes, that's my lord.
Ada.
Arvind, I give reply of the documents, my lord.
Not necessary.
My lord.
I am not seeing any other document. I am seeing your page. What is that page? 87. Heard Mr. Adas, the learned counsel appearing on behalf of the petitioner. Mr. P. Bhardwaj appears for the respondent numbers 2, 3, 4, 2, 2, 6.
My lord, one point is given, my lord. It is kindly see, my lord. Class 90, 54.
To 6.
54 of the
Other respondents are not represented. The instant petition has been filed by the petitioner challenging the decision of the respondent number 2 to 6 in selecting the private respondent number 7 to 9 by giving 7 to 9 and also for setting aside the select list dated 14/5/2012. 14/5.
14/5/2013.
12 or 13?
13.
13. 14/5/2013. 13, na?
Yes. Page 86.
Page 86 or 87?
Page 86.
2013. The facts enumerated in the instant petition is that an advertisement was issued Where is the advertisement? Dated
Advertisement is at 69.
that an advertisement was issued in the local daily, including the Assam Tribune and the Proceeding, whereby the respondent IOCS invited applications from intending applicants for appointment of retail outlet dealers in various notified locations. For the purpose of the instant case, the location is, what is that location?
Anajan on NH 31, serial number 81. Serial number 81, page 69. 81.
Location is Balajan on NH 31.
31.
Full stop. From the advertisement so issued, it revealed that in the said location was specifically reserved for women and in respect to what is the type of advertisement thing?
It's for retail outlet dealer.
No, no, it will be under what scheme?
So what,
No.
this for
Reserved for women for category. No, there are various types. No? As to
it is under open category reserved for women.
was specifically reserved for women. Full stop. The petitioner, along with various other candidates, applied pursuant to the said advertisement.
My lord, private respondent 7 is expired, my lord. Accidentally too.
And the respondent authorities held the selection and published a select list on 14/5/2013, thereby selecting the respondent numbers 7, 8, and 9 in the order of thereby shortlisting the respondent number 7, 8, and 9. The petitioner herein is aggrieved by the actions of the respondent IOCL authorities in making the selection without taking into consideration $60 marks which was specifically dealt with the capability to provide land and infrastructure of the facilities, and the capability to provide finance. It is the case of the petitioner that as the respondent number 7, 8, and 9 who have been duly selected in the impugned select list dated 14/5/2013 did not opt for the corpus fund, the petitioner credentials in respect to the capability to provide land and infrastructure oblique facility and the capability to provide finance ought to have been taken into consideration by the respondent authorities vis-a-vis the respondent number 7, 8, and 9. As the same has not been done, the petitioner therefore have assailed the impugned select list dated 14/5/2013 and had also challenged the selection process. The instant writ petition was filed on 2/9/2014, and this court, by an order dated 10/4/9/2014, issued notice subsequent thereto, by an order dated 17/9/2014, this court had directed the respondent authorities to maintain status quo, had directed maintenance of status quo on the allotment of the petrol pump till the next day. The record reveals that an affidavit in opposition has been filed by the respondent number 2 to 6 on 31/10/2016, wherein it has been mentioned
my lord.
Mr. Das, you want to stand, you keep on standing, otherwise take your seat. That as per clause 9B of the dealership selections brochure, in case of widows and unmarried women above 40 years of age without earning parents, for locations reserved for women opts for availing corpus fund, the marks on land and finance is not considered. It was mentioned that 4 applicants out of the 10 applicants had opted for availing corpus fund scheme. And as such, all candidates were evaluated for 40 marks because 60 marks were under the head, inverted comma, capability to provide infrastructure and facilities, inverted comma, growth, and capability to provide finance, inverted comma, close, was excluded. It was mentioned that as the marks on the land have not been considered for all the candidates. So asking for fresh land documents from a particular candidate after the interview had no meaning. The record further reveals that an affidavit in reply was filed by the petitioner against the affidavit in opposition filed by the respondent numbers 2 to 6. In the said affidavit in reply, it was mentioned that the selection committee failed to select the eligibility of the candidates strictly in conformity with the guidelines and also on proper evaluation of the land documents. It was mentioned that the selection committee had made the selection in an injudicious manner and allotted marks solely on pick and choose basis, and that too without actual evaluation of the documents as per the requirement and the preconditions as specified in the advertisement. It was mentioned that the stand so taken by the respondent authority that the remaining 60 marks under the head of capability to provide infrastructure and facilities and capability to provide finance was excluded was totally absurd and unreasonable in view of the fact that the corpus fund scheme was sought to be made available under the relevant guidelines brochures only to those candidates who were either a widow or an unmarried woman above 40 years of age without earning parents. And admittedly, the private respondent number 7, 8, and 9 did not belong to the said category so as to avail the benefits of the said corpus fund. In the backdrop of the above pleading, I've also heard the learned counsels appearing on behalf of the petitioner, as well as the respondent numbers 2 to 6, who submitted in along the lines of the stand taken in their pleadings. In the backdrop of the above, the question therefore arises as to whether there is any infirmity in the selection so made by the respondent authorities without taking into account the 60 marks specifically allotted for the purpose of specifically reserved for inverted comma capability to provide land and infrastructure of the facilities and capability to provide finance. The answer to the above can be found from a perusal of clause 9b of the guidelines for selection of petrol/diesel retail outlets dated 1/3/2012 of the Indian Oil Corporation. Clause 9b, taking into account the relevance of the said clause, clause 9b is quoted herein under. Page 55. From a perusal of the above clause, it would be seen that widows and unmarried women above 40 years of age without earning parents is required to file an application and make a request in respect to locations reserved for women and in that circumstances such applications will not be judged under the head, inverted comma, capability to provide infrastructure and facilities and capability to provide finance. It's also mentioned that these applicants will be required to indicate in the application form itself whether they would like to avail the corpus fund facilities. It was also mentioned that if the applicants do not indicate the same in the application form, it will be construed that such applicant would like to get evaluated in the line with other applicants. That is, they should also be assessed under the heads capability to provide infrastructure and facilities and capability to provide finance. It was further clarified that for determining the priority to be given to such candidates over the other women candidates, the marks secured by the other woman under these two parameters would be excluded from the total marks secured by them. Therefore, from the above, it would be seen that if an applicant who is a widow or unmarried woman above 40 years of age and without earning parents applies in a location reserved for women for the corpus fund, then in such circumstances, while evaluating the candidates, the marks secured by the other woman under the parameters of inverted capability to provide infrastructure and facilities and capability to provide finance would be excluded. In the backdrop of the above, if this court duly takes note of the facts involved, it would be seen that altogether 10 applicants duly applied. However, 2 applicants remained absent. Pursuant to the order passed by this court on 9/1/2024, it has been brought to the notice by the learned counsel appearing on behalf of the respondent IOCL that 3 applicants had applied for the corpus fund who were Srimati Madhumita Dwara, Srimati Pratibha Mohanto, and Srimati Urmila Rabha. The said Srimati Urmila Rabha remained absent. However, Srimati Madhumita Dwara secured 30.16 marks out of 40 marks, and Srimati Pratibha Mohanto secured 30.83 marks out of 40 marks. The petitioner, on the other hand, secured only 26.18. How much?
26.18.
18 out of 40 marks. And the respondent number 7 obtained 38 marks. Respondent number 8, how much?
Respondent number 8, 32.58.
32.58. And the respondent number 9,
30.83.
30.83. That is
Yes, the Pratibha Mohanto. 30.83 is the
30. who was 30 point, and the respondent number 8, who had opted for the corpus fund, had obtained 30.83.
Or 9.
Hmm?
My note has said respond number 8 between 9.
Respond number 9. 30.8. 83 or 16?
30.83.
No. 83. This court, now, having taken note of the said final mark sheet which have been enclosed as Annexure K to the writ petition, it therefore reveals that the petitioner had secured less marks than two of the women candidates who had opted for the corpus fund.
I do not opt for.
First of all, nowadays we are going to get it in Assamese also, this judgment. Then you read it properly.
Okay.
Further to that, taking note of clause 9b of the guidelines as which have been already quoted here in above, it would reveal that if there is any applicant who had opted for the corpus fund, and is in the fray, the marks in respect to the parameters in respect to capability to provide infrastructure and facilities and capability to provide finance cannot be taken into consideration. And as such, the respondent IOCL had therefore rightly, in the opinion of this court, did not take into consideration the said 60 marks. Taking into account the above, this court finds no ground for interference with the instant writ petition, for which the writ petition stands dismissed. Interim orders, if any, stands vacated.
Related to your lordship, affidavit has been filed on 19/1/2024, Malad, as per your lordship's direction, Malad.
Oh, anything improvement?
Status, Malad, page 3, paragraph 3, page 3, and Malad, 187 page number. There, Malad, that amendment process of the Assam Industrial and Employment Standing Order Amendment Draft Rule 2023 is going on. The Honorable Cabinet has approved the draft notification. It will be published shortly for obtaining suggestions, objections from all persons likely to be affected.
We will fix it after 2 months.
Lordship.
Taking into account the affidavit which has been filed by the
Labor and Welfare Department.
Deputy Secretary to the Government of Assam Labour Welfare Department on 19/1/2024. The matter stands adjourned to be listed again on 19th of March 2024. Full stop. On which date? And on which date The Principal Secretary to the Government of Assam Labour and Welfare Department shall apprise this court as to the status of the draft notification. The status of the Assam Industrial Employment bracket Standing Orders bracket Amendment Draft Rules 2003.
22. Apply.
For 9.
Your Lordship.
Hmm.
Lordship, this matter pertains to a state of an UTP inside the jail.
Huh?
State of an UTP inside the jail in a mysterious circumstances and
Oh, that matter.
yes. On 20
Then what to do?
my lord,
What are you asking for? Compensation?
compensation, judicial inquiry, compensation and judicial inquiry. Lordship,
Judicial inquiry. What is there to make a judicial inquiry?
my lord may kindly to the order dated 28/11/2023.
Hmm.
Your Lordship was sought for suggestion from both sides, who should be appointed as a commissioner for making an inquiry as regards the death of one of the.
Yes. What is there?
Well, actually, one retired district judge Majed Ali, he was there for a considerable period of time. I talked with him, but recently he has also. So I don't find any.
No, the commissioner will be very well there, but
Your Lordship directly.
no, this court will direct the, I think, the district judge,
Yes, yes.
Hemaji,
Golaghat.
Golaghat.
to further inquiry.
Keeping this matter pending.
No, this matter will be kept pending, and on the basis of the report, we'll consider it to whether it.
Yes.
The instant writ petition has been filed by the petitioner. Being aggrieved. Now, alleging that the son of the petitioner, who was in Golaghat jail,
Golaghat district.
Golaghat jail, died under mysterious circumstances. And therefore, to find out the truth, have approached this court by filing the present writ petition. From a perusal of the writ petition, it reveals that an FIR was filed on 2/1/2012 against the petitioner's son by members of Chetana Mohila Samiti, stating inter alia that the petitioner's son had physical relationship with one Srimati Bokuli Soitia on the pretext that he would marry her. It was also alleged that the petitioner's son had physical relationship with Srimati Bokuli Soitia and she was pregnant. And knowing so, the petitioner's son refused to marry, which led to the filing of the said FIR. On the basis of the filing of the said FIR, a Golaghat PS case number 9/2012 was registered under section 376 and 420 of the Indian Penal Code, corresponding to GR case number 12/2012. The petitioner's son thereupon was arrested.
Surrendered.
Hmm?
He surrendered for the learned citizen. Thereafter, he was forwarded to
He was arrested. He was arrested.
but he was surrendered before the
Understood why? Because this court directed you to
this
surrender.
court
Then,
directed to surrender.
but
Thereafter,
once you surrender, you have to be arrested, no? Isn't it?
he was straightway put behind the
Understood?
Yes.
You have to be arrested. Was arrested. And thereupon he was remanded to the judicial custody. Was arrested on 19/6/2012, and thereupon he was remanded to the judicial custody till 2/7/2012. The said period of judicial custody was increased from time to time by passing necessary orders by the learned. The said period of judicial custodial detention was increased from time to time. Full stop. It has been alleged in the petition that the petitioner had visited his son while he was lodged in the Golaghat jail, and his son informed the petitioner that he was suffering from severe chest pain with breathing problem as well as other physical complications. The son of the petitioner had also informed the petitioner about the mental torture he was meted with inside the jail. taking into account the petitioner further states that on 28/7/2012, when the petitioner visited the jail, he could see that his son had suffered, was suffering. So his son's health condition had further deteriorated, and the jail administration was not doing anything. And under such circumstances, the petitioner had lodged a complaint before the learned CJM Golaghat about the negligence of the jail administration, and also for a direction for proper treatment of his son by an expert doctors. However, unfortunately, the son of the petitioner expired on 31/7/2012 due to on 31/7/2012. The petitioner was informed that the son of the petitioner expired due to cardiorespiratory failure. At 12:35 a.m. on 31/7/2012. Thereupon, a postmortem was conducted. Autopsy was conducted, and a postmortem report was prepared. This court finds it very pertinent to take note of the said postmortem report, wherein it was opined that all the changes are what is this?
All these changes are anti-mortem in nature. Anti-mortem. All the changes are anti-mortem in nature. And the post-mortem examination done within 24 to 36 hours of incidents.
All the changes are antemortem in nature, and the postmortem examination was done within 26 to 34 hours of the incident.
24 to 36.
24 to 30.
24-36 hours of the incident. It was also opined that the said portion of the postmortem report is quoted here in below. Where is it? Properly given somewhere?
My lord, page 31.
That I could see, but it is very difficult to read. Half of it is not there.
29 is the type copy. 29.
Where?
29 of the read.
I have a clear copy, madam.
Oh no, 29. Type copy.
Type copy is 29.
In affidavit also filed by the respondent number 2, madam, 2 entry earlier. It's a part of record.
The relevant portion, the relevant opinion of the postmortem report, the opinion in the postmortem report having relevance for the purpose of the instant case is quoted here in below. From the above report, quoted portion of the report, is also very pertinent to take note of. that it was opined that the cause of death is due to synop resulting from coronary artery insufficiency, probably due to underlying cardiomyopathy by the deceased.
Cardiomyopathy.
It was also opined to rule out any poisonous cause. Two containers containing the viscerous were sent to forensic examination. The petitioner thereupon filed the instant writ petition seeking a judicial inquiry into the matter as to whether the jail administration had neglected the health condition of the petitioner's son, thereby failing to provide the proper treatment to the petitioner's son in time. The record reveals that an affidavit in opposition has been filed by the respondent number 2 and 3. Stating various things, various aspects. Stating inter alia that the petitioner's son's co-prisoners, namely 1 Okon Ali, Roman 2 Raju Bora, number 3 Nitul Bora, and number 4 Dipson Borua, who were lodged in the said ward number 1, stated that on 30/7/2012, at the time when they were going to sleep, the petitioner's son was reading a book. In the midnight at about 12:30 a.m., the said co-prisoners were waken up by an unusually hoarse sound coming from the throat of the petitioner's son, and he was found gasping and thereafter lay unconscious in his bed. It was mentioned that the duty warden, Sri Lokinath Gogoi, was duly informed, who rushed to ward number 1 to see the petitioner's son, who was lying in an unconscious state. And thereupon, the doctors examined the petitioner's son at 12:40 a.m. and declared him dead. It was also mentioned that there was a magistral inquiry so made.
That report is not annexed with this affidavit, madam. Second affidavit it was annexed.
Where is the second affidavit? Magistral made.
Page 61. Internal.
Full stop. The said magistral inquiry report dated 6/8/2012 have been enclosed to the additional affidavit filed by the respondent number 2. From the said perusal of the said magistral inquiry report, nothing new. Nothing what has been already stated here in the above. No. From the perusal of the said magistral inquiry report, it was mentioned that the cause of death may be due to heart failure, but the final cause of death can be known after receiving the forensic laboratory report. This court further finds it relevant to take note of that the instant reputation was listed before this court on 7/9/2023, whereby there was a direction being given by this court to bring on record the inquiry report of the executive magistrate, and accordingly, the said inquiry report, as already stated here in above, was brought on record by way of an affidavit filed by the respondent number 2. This court on various occasions had directed the respondent authorities to produce the forensic report, inasmuch as from the very postmortem report, it was clear that 2 samples containing the vicious of the deceased was sent to the forensic examination.
Letter X is the last instruction.
However, nothing could be produced to that effect by the respondent authorities. Finally, on 28/11/2023, it was informed to this court that that there was no record found in the CD sending of the viscera to the director, FSL, Kahilipara, Assam. This court finds it astonishing as to how there can be no report of the forensic science, forensic examiner, that to when the viscera of the deceased was duly sent to the say for examination, for chemical examination. This court also finds it very pertinent. What was the age of the victim?
Age of the victim,
30 years. To take note of that the victim's age at the time of his death was 30 years. And the question duly arises as to whether the jail administration had neglected in taking note of his health condition. And providing proper treatment. This court also cannot be unmindful of the fact that Article 21 of the Constitution categorically mandates that a prisoner convict under trial prisoner, the under trial prisoner convict has rights, has the fundamental rights under Article 21 of the Constitution. And these under Article 21 of the Constitution. And this right includes the right to proper medical treatment, which is a basic human right. This court, however, is of the opinion that these aspects can be only found out, can be discerned upon after making a thorough inquiry accordingly, this court, in the interest of justice, directs the district judge, Golaghat, to conduct an inquiry as regards as to whether and conduct the inquiry in reference and submit the report before this court. By 6th of May 2024. The terms of reference for making the inquiry are, number one, whether there was any negligence on the part of the jail authorities in providing the adequate medical facilities to the petitioner's son. Which led to the death of the petitioner's son. Number two, whether the responding authorities ought to have been more, no. Whether the death of the petitioner's son occurred due to cardiomyopathy along with coronary artery rupture or for any other cause. Number two, full stop. The superintendent of police, Golaghat, and the jail, who will be there? Superintendent. The superintendent of jail, Golaghat, Golaghat district jail, as well as the he will do it, call for them, no? Should I give any direction to these authorities? No, not that.
District
The
judge himself,
district judge
district judge
will-
himself may take up.
He
matter.
himself-
District judge,
The district,
for that reason, probably a set of papers has to be provided if it is went for it. It went for it.
My lord, may poisoning part, it may be a case of poisoning.
Huh?
Other part already lordship has reflected. It may be a case of suicide inside the jail or poisoning, maybe, because on that particular day he was produced to court on remand. But that day the incident of, we don't know, my lord. what
It's
exactly
okay.
happened.
And anything else, I don't think. On 6th of May, that's 4 months. And the registry is directed to furnish this, send this order, transmit this order to the district judge Golaghat, along with a copy of the pleadings of the instant proceedings.
Obliged.
The
My lord, first their report, it seems, my lord, they have not sent the detail.
Huh?
As per
Ah.
their last,
Did not.
it was not sent.
Okay. Expect.
Deeply over. Clear, man?
Yes, what is this?
I also inserted the particulars. Another date. Next week, any date.
Is your insurance covered?
I get that my case is covered, but they have said that it's not covered yet.
So your insurance policy will have to show whether it is covered or not.
That from page 10 to
Burglary, housebreaking, including larceny or theft. Fire, allied perils, building of glass and construction, fire, including jewelry, valuables, belonging. Then, therefore, investigation of flood damage. Flood is not covered.
No, the flood is covered. What had happened was, as per the insurance company, their version is that it is not flood but erosion, and erosion is not covered. As per his own statement in the Philippine, he has filed in the Philippines, he said floods have been occurring recently every year. Now, if in insurance laws, if what is regularity, regular occurring phenomenon that is not included, there's some element of uncertainty. They found their survey, they had also engaged the survey. Survey says it's a case of erosion, not flood. Because erosion does not wash away the half part of the house. It must have been flood. The house was standing in the special only half part of it was standing on soil, ground. Half part was hanging like so it was not a case of flood, but he said it's a case of gradual erosion over a period of years. And as per his own statement, lost in para 6 of his affidavit, he said floods have been happening in the recent years.
Where?
In para 6 of his
Affidavit in reply.
even in reply.
Yes.
So that was the reason basically para 6 note. That with regard to the statement made in paragraph 6 of the affidavit in opposition, the deponent begs to state that the deponent insured his house with a National Insurance Company Limited under the scheme of householders insurance policy being policy number so which effect from 5/5/2010 to 4/5/2011. And subsequently it was renewed till 9/5/2013. And during the course of insurance on year, the house of the deponent was damaged due to great flood. The residential area of the deponent is a flood affected area. And every year the flood damaged the household articles and the house of the deponent.
that covered.
Then the next line.
Next line, therefore, as per advised of agent of National Insurance Company, the deponent insured his house with the National Insurance Company under the householders insurance household scheme policy in the year 2010 and subsequently it was renewed. At the time of opening of insurance policy, the survey of the insurance company visited the house of the deponent and after duly satisfied, opened a policy in favor of the deponent. It is not a fact that for fulfilling of the malified intention, the deponent opened a policy for a few days ago of the damage of the house. We had denied the later part of the year that no one had visited his house. His premium came to 300 some rupees and engaging any survey cost minimum 2,500 rupees. So that is no one will do it economically.
Fire special perils for building. What are the components? Storm, cyclone, typhoon, tempest, hurricane, tornado, flood, and inundation.
These are the disputed facts.
During the flood, you have received the house of the
Hmm?
Flood is covered here.
Flood is covered. And it happened because of the flood,
Because of the flood. Here.
not erosion.
Suddenly the flood was to come here, the great flood during the flood you have received. During the great flood, you suddenly water come and water comes part of that.
But is it your admitted stand anywhere that there has been any erosion earlier? You only say that there has been flood, Thompson flood, but it damages the article. Nothing more than that.
Some part of the house
Is being taken away earlier.
not earlier, during the police.
This time only it happened,
time,
not earlier.
Not that.
That is what, na?
In the 2010, it first police was opened here. After second time renewed here, the third time
In page 10 is the first policy. First policy in 2005-2010 to midnight 4/5/2011. Second policy are renewed on 10/5/2011 to 9/5/2012. And the instant policy 10/5/2012 to midnight of 9/5/2013. An incident took place 6/6/2012.
Now, is it your finding, anybody's finding out there to the effect that there has been continuous erosion?
The survey has given that.
What is the difference between erosion and floods damage
Erosion also
and the floods resulting in erosion?
Yes, so there's some the difference between that. Erosion can happen even without flood. It can keep on the river banks. Sometimes we see there is no flood, but some parts of the soil are just going under that. And floods normally in some cases come and go. They wash away the articles, maybe also damage a lot of the house. The walls can also be affected. Goods are affected. Erosion is that to the way house is standing at the moment.
Do you have any
half
policy?
the house is on.
Do you have a policy for erosion?
There's no policy for erosion. Erosion is usually not a covered. What is covered is payable and values. What is not covered? When they have taken so many items, like the same name, for the same thing, flood, storm, tornado, and salt synonymous there. But erosion hasn't kept up. Erosion is also a water related. All these water related storm, flood, typhoon, tempest, everything. Why was erosion? Because it can also happen regularly over a period of time.
When do you want to do it? Is the matter on 6th of February 2015. Yes, Mr. Deka, what is your matter? That matter? We have 15 minutes. What is their stand?
No, they said that they could not trace out the records. They filed an affidavit to the effect that they could not trace out the record despite search.
Records for what?
The land acquisition case record.
Land acquisition?
Oh, my lord, the LA case. It was a proceeding under the taxation of ceiling on land holding tax. Now, I'll very quickly place the background, sir. My lord, my ancestors had several parcels of land. Out of that, 2 pattas are important, patta number 3 and patta number 9. Now, we were always under the impression that patta number 3 had gone into ceiling and patta number 9 is our retainable portion. 2009, my lord, we find in the Jamabandi that the entire patta number 9 is shown as ceiling surplus and is shown as sarkari.
And 3?
3 is also shown, my lord. 3 is a different. Now, we accordingly file RTI application. From the RTIs, it is revealed that my ancestor, my predecessor, had made a choice that I will retain patta number 9, you take everything from patta number 3. There was also an order by the ADC concerned which said that we are entitled to 250 bighas. But however, the ADC did not specify which all patta or dark numbers would be the retainable portion. Though we selected 9, there was no...
This is under the 71 Act?
Yes.
And
56, I think. 56.
Some fixation.
Fixation.
Then,
my lord, we filed an...
But doesn't it require a preparation of a...
Exactly.
What happened?
It requires a preparation of a final statement, my lord.
So no final statement?
One final statement, it is shown, the number is shown as a draft statement. There is no signature of the collector. That was furnished to us in the RTI. Now, we preferred an appeal under 7.6. We preferred an appeal under 7.6 and a report was called for. The circle officer furnished a report saying that the final statement was never published. There is no record of the final statement. Patta number 9 land is still in possession of the pattadar. No compensation has been paid to us. And there is no indication in the final statement as to what are the plot numbers of the retainable portion. So that report was in our favor. Despite that, there was no orders passed. We moved a writ petition, my lord, earlier on. We moved a writ petition and we said that our appeal is not considered on merit.
this honorable court directed that the appeal be taken on board and be decided. Now, the appeal was dismissed on the ground that we had run out on limitation under 7C. 7 subsection 6 of the Act. Now, 7 subsection 6 says that the appeal has to be filed within 1 year from the date of publication of the final statement.
But there is no final statement.
Yes.
So the appeal is also meaningless.
But since there is no final statement, I could not have preferred, my lord. I filed a review, my lord. Now the commissioner again admits that yes, there is no publication of the final statement. It also admits that the land is still in my possession. It also admits that it does not record what is my retainable portion. And additionally, it also records that there was actually no handover of possession also, because there was an endorsement in a Mondal report that my ancestor had handed over possession, whereas my ancestor had died long. Now, despite all of these clear findings, the Revenue Department eventually holds that though there are irregularities, we will not venture into this because it is too late in the case. Now, additionally, my lord, thereafter we come to know that this particular entire village was classified as a town land way back in 1966. Now, if it becomes a town land, my lord is aware of the position that all these acquisition is made under the 1956 Act, so that eventually it can be settled with agriculture. Now, as per the land policy of the relevant time, my lord, town lands cannot be settled for agriculture. Now, if that be so, the very purpose of acquisition is meaningless because eventually you cannot settle it with agriculture.
But where is the acquisition? But where is the ceiling? First of all, the ceiling is
exactly.
Why we are going so far?
My lord, that because, my lord, there are others, my lord, who were relieved of that acquisition on that very same ground because
very good. But the fact that without a 7-4 statement, how is it for 7-6 statement? And there is no finality to the ceiling to see.
Yeah.
Isn't it?
Yes.
Then
foundation is not there. If Lordship may be pleased to come to page 169. That is the stand of the department. I cannot travel beyond it. This is the order passed in the review application. Revision.
160?
169. It starts from 167. Lordship may kindly come to 169. It is just below the first paragraph. Petitioners have paid either. Lordship got it? This is their claim. Petitioners have paid either A, to exempt the said 158 bigger 4 kota till of land covered by NK Potta number 9 village Ni Senduri Gupa under Sila Senduri form being townland from acquiring under ceiling case number so and asks DC Kamrup to start a ceiling case afresh over the remaining portion of land belonging to the petitioners in village so and so covered by so and so respectively and acquire the land if found ceiling case. Then or to allow the petitioners to retain the said 158 because 4 kota 18 letter of land under NK Potta number so and so and acquire the land if found ceiling access from Potta number 2 and Potta number 3 in village so and so respectively belonging to petitioners through ceiling case number so and ask the DC to correct the land records accordingly. The Pottadars preferred an appeal before the Honorable High Court.
No, these are okay, but without 7-6, how is it possible?
That is the genus, that is the foundation.
Without that, you can't help anything.
First of all, yes, first of all, the authority will have to quantify. This is the land, this is the land you are holding, this part is surplus.
So that proceedings did not come to an end.
Yes.
The entire ceiling proceedings so initiated under that provision
yes.
that has already left, become redundant.
Redundant. So,
unless you may do whatever you want to do, whatever, but otherwise you have that proceedings have become redundant. You made afresh do whatever maybe you can.
Yes. For that reason, Lordship has made an attempt to call for the record. And records and to that extent we have filed an affidavit. It is because of the reason, my lord, that due to bifurcation of Kamrup Metro and Kamrup Rural, authorities have communicated. Their inter-office communications. I have enclosed it.
Where is the land?
Silas Indrigo. I mean,
Available and now it is all industries are being set up there.
And that land is in your possession,
it's in my possession.
250 bigas,
1/8,
150.
1/8, 1/8 here.
Otherwise, only maximum is 50 bigas. 50 bigas and that to aggregate. Definition of family is also there. It is not that in a family there are four persons, 4 of them can individually hold 50. It has to be aggregate. Admittedly, it is surplus land, but only because of the fact that, my lord, these proceedings were not drawn up. In
Now
proper
they
manner.
can be
Yes,
drawn up.
that-
No, my
that-
lord, wait, my lord, one thing, the collector had already held, my lord, I found out the RTI application, that we as a family were entitled to retain 250.
That is immaterial. You see, the collector, all these proceedings have become honest. Now, are you saying that you are to go back to that particular position of that and only ask them now to come up with a 7-6 notification? You want that?
No, we don't want that.
And if you are relying on some part of it, why not we give them the opportunity to issue a notification? Isn't it, Mr. Bob?
Yes. Now they are basically claiming, my lord, page 19 of the petition. I am troubling, my lord. All this. Page 19, man. This is their prayer. They are basically aggrieved, my lord, by this order, my lord, which I have just now drawn my lord's attention at page 169. The order passed by the department on a revision.
Where is the final statement?
There's no final, my lord, they
If there is no final statement, why you are challenging a final statement?
my lord, they had given me that 87B, my lord, in the RTI, pursuant to the RTI reply, my lord, they had given us a unsigned final statement, which is at page 87B of the writ petition. Now that merely indicated we've taken over my lord, 310B. Page 87B, if your lordship takes that.
You see, all these proceedings, in my view, is completely honest. Unless they pick up now, you see, if 7-6 is not done, is there a time limit to do the 7-6? I think there is a time limit. Now you have some fixation on land.
Yes, time limit is 1 year.
Then it has got all become, this has become elapsed.
Yes,
The
7-6
proceedings have elapsed.
Yes, now 7-6 says, my lord, without prejudice to any action under any provision of this act, the state government may, on its own motion or on application, if filed within a period of 1 year from the date of publication of final statement under subsection 4, or from the date on which the
No. That is an appeal.
This is the
I'm saying about the final statement. What is the period for final statement?
my lord, it just says the draft statement shall then be made final in terms of the final order.
Now, is there a limitation?
No, my lord. There's a limitation for me to object within 15
That
days.
is a different, but
Otherwise,
7-6 is not done. So, unlike Assam Land Acquisition Act, you have to do, the award has to be passed within 2 years.
Yeah.
Is it mentioned
No,
out here?
no, there is no
Then,
such
then the proceedings doesn't become honest.
proceedings doesn't become known.
So, but as of now, 7-5, without a final statement, the land cannot be made sarkari or whatever may be.
Yes.
So that only interference is giving you the liberty to take action further in terms with that case.
no, but my lord will then also consider whether it is at all amenable to the provisions of the act because it is included as town land.
Which one?
This particular land.
No, they will take a decision. You file your 7-6 then, once they do. As of now, I'll stack off this and give you the writ of mandamus to release the land. Because as of now, nothing has happened.
Correct.
So the only thing is giving them the liberty to further proceed with the LA case, that case. If they want to do it, they'll do it. Otherwise, if they don't do it, then don't do it. What do they? They have to bring a finality to that.
Now, yes, now he has made a submission, my lord, that town land is excluded. The exceptions, my lord, that section 2 says the provisions of this act shall not apply to land held by state government or union or local authority or by any agricultural farming corporation, so and so. Then, my lord, two lands held and utilized for special cultivation of tea and purposes ancillary thereto, land held by mill, so and so, land held by cooperative farming society for cultivation of sugarcane only, provided that any time which such land causes to be utilized for the purposes mentioned, so and so the provisions of this act shall apply. Land vesting in Gram Sabha. These are the only exceptions.
That is why I don't understand how you bring in the townland because this is not there.
Townland is not specifically
Not given here.
It is not there. Townland.
Oh, no, but there are a judgment, and there's also an order by the deputy secretary.
Deputy secretary.
I'll highlight on that point.
No, don't highlight on
The other point. There are judgments of this
Since
court.
that argument is coming from that side, it is my duty to find it.
I'll just place two judgments. Our High Court has said, land within the meaning of 3F must be land which is capable of being settled for agriculture. And in fact, there have been cases where
no, if you see the Assam land fixation of land ceiling act, kindly see, it doesn't prohibit it. Assam fixation of
3F definition if the lordship.
Exceptions, lordship will find at section 2.
Assam fixation of an exception.
Yes.
The provision shall not apply to the land held by the state government or the union or in local authority or so and so. The land held by utility, land held by mill, factory so and so, set up so and so, but not for any land held by so and so. Provided that if any such land is to be utilized for purposes mentioned by the provision.
Townland is nowhere mentioned.
Yes, what you have mentioned, land. Land means land which is or may be utilized for agricultural purposes or purposes subservient thereto and includes the sites of building appertaining to such land and includes land which is or may be utilized for quarrying stone. Then, what is the problem?
My lord, will two judgments,
Where?
Two judgments, of our High Court.
Of which judgment?
Of our High Court.
Which year?
My lord, 70.
70? That is why amendment has come in 75.
My lord, there's a judgment of 94.
What does it say? They did not look into 75.
73, my lord, is by a division bench.
Maybe, but it is not taken into account. 75. Here, see, utilized for agriculture or purposes of and includes sites and building appertaining to such land. Means any such land which is or may be utilized for agriculture or purposes and includes sites of building to such land, includes land which is or may be utilized for quarrying. But here, the division bench did not take into consideration the which has been excluded, the exclusion, section 2.
My lord, it basically focused on the object because ultimately whatever is acquired as stealing purpose must eventually be settled as per 16 and 17.
May not be made, made government.
My lord, the object is to eventually settle it for agricultural activity.
Which is or may be utilized for agriculture or purposes subservient thereto, and includes land which is or may be utilized for quarrying stone. I don't understand why this portion is not there. This judgment or purposes subservient includes land, but doesn't include the sites of buildings appertains to such land, includes land which is also maybe utilized for quarrying here. That is not being mentioned. And directly relied upon that judgment without applying that there has been an amendment in 2000.
And
No,
section
my lord,
16, section 16 and 17 are, my lord, mutually exclusive, my lord. Section 16 and 17, my lord. These are mutually exclusive provisions, my lord.
There is any cultivatable tenant in occupation of land
Yes.
acquired from any owner, then he shall be given settlement.
within a prescribed period on the following conditions. That is one, my lord. Then, my lord, on payment of full amount so and so, where the then lordship will kindly come to subsection 3 of section 16, where the excess land is acquired from a tenant as such, and from the owner thereof, the state government shall be entitled to settle it on such terms as it may fit with the subtenant so and so. Then section 17, kindly see, my lord, manner of disposal of which is not settled under section.
It has not been disposed of under in 12.
Yes.
12 will be the then come the settlement rule.
Settlement rule. So these two provisions are mutually exclusive. The government may settle, government may not settle. Government may take an exercise under 16 if the government thinks that no, not to be settled. Then 17. So this is not the object, my lord, in my respectful submission. And kindly see, my lord, the preamble to the act.
No, when there is section 5, section 2,
Yes.
which categorically accept that these are the things which
Yes,
cannot,
yes.
how can you say that this
Yes.
provision would not apply?
So external aid for
And
interpretation can be-
Assam land policy concern.
The next that 140.
Land
Right,
policy, land policy, does it say town land cannot be settled?
That's page 140 of the writ.
And it can only be settled for agricultural purpose.
That is what the judgment said.
No. It
12,
can't be.
of course, if we fall back on 12 of the Assam Land Revenue Regulation, my lord,
Then
my lord, it is for settlement of all wasteland.
then
But so far as
only 16 will come for that, but 17,
17 also, my lord.
which is for at the disposal of the government under
Yes.
section 12.
Yes.
Then,
Yes. So
So-
therefore, yes.
and this amendment was brought in 8. Kindly see, this was brought
My
in
lord, we will
71.
see subsection 3 of 17, my lord.
No. Subsection 3. In making settlement under 1, a preference shall be given as far to landless cultivator who have been rendered homeless due to flood erosion. Landless cultivator are defined a preference only.
Preference. Because ultimately, my lord, this was for agrarian reforms, my lord.
Then why was the 1971 Act there? Urban Land Ceiling Act?
Urban land seating, my lord, was for a different purpose, my lord. They defined something as an urban conglomerate, my lord, for all developed areas. For that, they had identified locations, and within a radius of that particular epicenter, my lord, they had declared urban conglomerate.
Yes.
Now is it the thing that town land cannot be settled for agricultural purpose?
My lord, the land policy of the relevant time, my lord, I have annexed at page 140.
No. Now we are happy with land policy of 2019.
My lord, they had initiated that.
As of now, they have not.
Not- Then, my
Okay.
lord,
Release the matter on 25/1/2023, 24 for further So that is your answer. We have to set aside whatever has gone, giving them the liberty to do whatever, and whatever name you have put there, remove them name, then you have to bring it back, and then do whatever you feel. And against that, let him file an appeal with a fresh paper.
Yes, sir. And they are also duty bound under the statute matter to submit their return, because filing of return is the condition precedent before preparing the settlement.
Understood. You have to initiate the process now. They must have submitted the return earlier.
My lord, all we found was
Return-
an application,
return they
but
will have
even
to
if you don't submit the report, return, they'll have to prepare the return. my lord. Which they have to eventually.
No, if they don't submit the return, it becomes more easier for you. They can't get the exceptions. Yeah.